distinguished ladies and gentlemen, thank you very much for making it here in good time. Welcome to day 2 of the sessions for the Law Week. Yesterday, we had a very great time apart from the opening ceremony. We had 2 sessions where fundamental issues were discussed. The first session looked at access to justice in rural areas of Nigeria, issues and challenges. Second session, the second business session, focused on judicial independence and accountability, realities of the time. And I'm sure we all remember that we were going to actually take so much more time to discuss this very crucial issue. But of course, we had to go. And I'm sure that the sessions today will be much more exciting. Let me humbly request that we should all move forward. Please, let's occupy the seats in front so that we will have an organized house. The cameras are rolling and we need to be proper in the way this conference is viewed. The conference, the Law Week, the sessions are also being broadcast live on Joe Television, so it's important that we are a very organized house.
Without prejudice to the well-established protocol yesterday, I respectfully welcome my noble lords to this second special session this morning, which section is now going to consider quite a number of topical issues that relates to the advancement of our dear country, particularly the electoral system and the administration of criminal justice, the prison system and others. So we are hopeful and very much optimistic of the fact that as it was yesterday with the first and particularly the second session yesterday, ably decided over by my noble Lord that today will be of great and immense benefit to members of the bar and public. And of course, let me also especially greet our dear father, in whose honor we are also celebrating this year's Law Week, Senator Dr. Bode Olajumoke. Daddy, you are welcome, sir. You came quite earlier than many of us, notwithstanding your age. We are grateful, sir. God bless and enrich you, sir. So, ladies and gentlemen, we are now proceeding to the business of the day, and we have been well informed of the fact that our discussants are already seated. And today's business is a continuation of yesterday. So, as I've said, so on this note, we are now proceeding to constitute the panel begin the business of the day.
Barrister Shola Shafi, your attention is needed here, please, very quickly. Thank you very much. Okay, so today we will have 3 business sessions. The first business session will focus on correctional reforms, pathways to rehabilitation, and reintegration of ex-inmates. The second session for today will be on promoting electoral justice through legislative and judicial interventions. While the third business session, will have as focus judiciary as a catalyst for economic development, efficacy of court judgments. I'm sure that this last session will be very explosive, essentially because of some of the issues raised at the second business session yesterday. I remember that yesterday Justice Olorundaosi made some very explosive remarks about issues that define the operations of the judiciary. And I also remember that some of the participants who asked questions and made comments actually had very dash remarks, And so I know that this third session will be very exclusive. Of course, it is the 5th business session of the law week, but it will be the 3rd business session for today. Well, the chairman of session for the first session for the day is Honorable Justice Ademola Enikume, and I'll quickly go through the list of participants, the chairman and discussants. While the discussants will be Oluwanike Omotayo Esquire, Taiwo Olubono, the DPP, Adeyeye Olumuyiwa Ademola, and Justina Akeredolu. These are the legal practitioners who will be dealing with the conversation for the first business session. So just wait for about 5 more minutes for more participants to come into the building. So let me quickly welcome and respectfully to judges who are in the building. I'd like to respectfully welcome my Lord, Honorable Justice Kolawole. Let's put our hands together for him. Thank you very much for joining us at this event. Thank you. Thank you so much. You know that judges are exceptionally busy people, but for quite a number of them to be in the building today shows how much importance they attach to this event. I'd like to also welcome my Lord, Honorable Justice Sunday Olorundaosi. Justice Olorundaosi, thank you very much for the second session for yesterday. It was quite Let me also welcome my Lord, Honorable Justice Ademola Enikume. Thank you very much for joining us at this session. I'd like to also welcome Honorable Justice Professor Alero Akeredolu. Thank you very much for joining us at this event. I'd like to welcome Honorable Justice Bubi Fabio. Thank you very much for joining us at this event. Okay, so we will hit the ground running quickly, and more introductions will come later. But let's please forgive us for that omission. I'd like to also welcome Honorable Justice O.J. Amy. Thank you very much. Welcome, Honorable Justice Magot. Thank you very much for joining us at this event. Okay, so we'll move on to...
In addition to that, we also respectfully introduce and also recognize the presence of our leader at the bar, who significantly just been elevated in the rank of senior advocate of Nigeria. He is a member of the planning committee, and that is Prince Adetuji Osho.
Thank you very much for joining us at this event. Anyway, it's your event actually, so you're not joining us, you are hosting us. Thank you very much. Okay, so let's go on to the first business session.
The first business section is entitled Correctional Reforms, Pathways to Rehabilitation and Reintegration of Ex-Inmates. I think these orders of Administration of Criminal Justice, and we have seasoned resource persons or discussants who will engage us on this crucial part of our justice system. This session will be chaired by my Lord Honorable Justice Ademola Enikuomi.
Distinguished ladies and gentlemen, let's put our hands together for Honorable Justice Ademola Enikuomi as he steps to the seat reserved for the chairman of the first business session for today.
And of course, members of the panel, Oluwanike Omotayo Esquire.
Let's put our hands together for her as she comes to the seat reserved for her.
Of course, we also have our seasoned practitioner, Mr. Taiwo Olubodun, Director of Public Prosecution, Ministry of Justice of the State. Equally, we have Mr. Adeyeye, Olubuyiwa Ademola, is also a panelist in this session. Please come forward. And the last but not the least, Ms. Justina Akeredolu, please kindly come forward. So she was a member of the panel.
All right, thank you very much. These are the men and women who will be doing justice to the first session, the first business session for today. And straight away, I guess the fourth discussant is yet to come into the building. Well, we'll have to move forward. Let me now hand over the microphone to the chairman of the session, Honorable Justice Ademola Enikuomi. Thank you very much, sir. Please go.
Thank you very much. Ladies and gentlemen, with very special recognition of our father, Dr. PhD. You are welcome, sir. We thank you for the efforts and everything you have done on the bar. My Lord, ladies and gentlemen, today we are getting into what we have called business session, and the topic is judicial independence, correctional reforms, pathways to rehabilitation and integration of ex-inmates. Of course, this is a topic that speaks to a lot of things that we relate with on a daily basis. Somebody once told me that if you want to know how decent or how well prepared or how organized the country is, you look at their weakest points, how they treat their vulnerables, women, children, those in detention, and rest of them. So this question speaks to a lot of things. Correctional reforms. In the last 6 years or thereabouts, the government of Nigeria tried to initiate change by changing what we used to know as the Nigerian Prison Service to Nigerian Correctional Service. Of course, that is to tell you that the focus of the attention now is to bring reforms to the prison and correctional service or custodial services generally. The question is how far are we going with that? Is it only in the laws or is it reflective of change? Do we see changes in the street? Do we see changes in reality? And that is the purpose of which we are gathered today. And I'm sharing this moment, this particular session with very peculiar people. I have with me Mr. Dario Obodo, otherwise known as Dario Dario. He's the DVP and a very experienced attorney. Mr. Obodo, you are welcome. We also have Nika Omotayo. I call her Nika Lala. She knows the reason. Nika is a body attorney with a substantial practice based on foreign. It's a pleasure to have you here. I have not related with the name of but I know that you have a personality that speaks to the situation, and that's the thing about it. May I know the name? Oh, J.J. Akedolu. Okay, I've had a name, but I'm relating with you for the first time. So you are welcome as well. We also have a very peculiar person. He will tell you a story. I'm not going to tell you a story, but it's somebody who has interacted with this system and who has the wherewithal, who is absolutely qualified to speak to the situation this morning. But to kickstart it, data suggests that there are activities, that is people who commit crime, get punished for it, come back again, repeat offenders. So what we have today, more than 40% of people in the correctional center are recycled. There are people who have committed before, found their way, and came back again, go back to society. Therefore, how long do we continue this? That's the question that speaks to reformation. Are we truly reforming? Do we have a policy for reformation? Is there a pathway for reformation? Are we integrating people back to society? We are looking at it from different perspectives. And to kickstart it, let me ask Mr. Obodo, what is your take on all of this?
Chairman of the session, I'm honored to have the opportunity to be here to say a few things in respect of this topic. It's an interesting topic, and we also have to thank the planning committee for choosing this topic. The topic is central to our living. The chairman, we want to know how the country is how
ẹnìyẹn láì ló yẹ kẹ ẹ mú ṣọ́ọ̀tì ẹ̀ díẹ̀ díẹ̀ ni wọ́n bá ṣe wà ńlá kínní ẹ̀ ní ẹ̀rẹ̀ nígbà àwọn mẹ́ta yá rẹ̀.
to make the conditions of inmates move from restriction to transformation to main treatment
inmates. But if you look at the situation, can we say they have achieved that end? Truth of the matter. But I will hardly away from where we were before the 2018 enactment of the correctional service. Today, if you go to the correctional centers, you still see those things we experienced when we were called to the bar. What we have today is still appalling. So it shows that it's not just the status that matters. It is doing what the status provides for, implementing the provisions of the statute. And the challenges is principally funding and attitude. Attitude in the sense that people don't deliberately go ahead to implement these reforms. It's not just seen in passing. There will be conscious effort to reform. Every stakeholder show interest. But as it is, it's as if they only pay lip service in the issue of reforming the correction. This is similar to what happens in every physical part of our country. Now, information. The question is, the department in charge of information, to what extent are they trained to inform inmates? Because if they are not properly informed, when they come out, the tendency that they go back there become extremists. They will go back. This is what we experience as prosecutors all the time. Somebody will be prosecuted, so we have to still find the person being prosecuted again. Right now, as I talk to you, on my table, I have somebody who was listening to the police that his younger brother who is at that because they arrested the younger brother who was in case. Now that same person, the younger brother is telling a lady that his younger brother has committed is a criminal, saying that he's a criminal. When he was committed, he's a criminal. But I am not part of the crime now being committed. And younger brother is a criminal. Shows that, and you said that they have been to prison several times. That can't defend you, can't say they live with. So that is the experience we have. And this experience is very common. So our coming here today and talking about personal, I think we should be looking at what to do to ensure that the corrections are really reformed. And when we say reform, we are not talking about the buildings. We are not talking about making people that are doing human beings, people that behave well in society. They have been that the set concerted efforts by all stakeholders. And when we say stakeholders, we are not talking about people in the judiciary, people in the executive, the executive, the legislature, they are also stakeholders. They should show more than personal interest in the problem at hand. Now, then another issue is the issue of integration. Now, talking about integration, in fact, that is really the worst aspect. When people leave prison, nobody cares about them. Nobody cares about how they will eat, where they will stay, or the rather, how they anything about their life. Nobody cares about them. And there is this issue of stigma because the society is afraid of setting them back, thinking, believing that they must still be criminals, whereas they ought to have been informed. And you can't blame for having that mind because to one extent I didn't really reformed. So you don't find acceptance within the community. Nobody wants to be there. So it's the duty of government to think of how to do this. Because the population continue to increase. It's really giving the kind of economy we have to develop without the information. But the truth of the matter is that except we have a program as done in the US where we have public-private partnership in respect of people who live in prisons. They call it re-entry. So they have a program, that program is well funded by the government and the private sector. They come together, collaborate, and find solutions to these problems by ensuring that before they even the program was started, even before they leave the prison, they will start the integration before they leave prison. Where they will live, the accommodation, they have daily living, everything. provided for. So that way, most of them will go back to their because they can only join the society meaningfully and contribute to the society. I have a suggestion. I look at that government ought to adopt the model of NKS, where there's a kind of social NKS. So it's where there's a kind of a social protection program that most people that are doing business they have their data, the statistics, and then in a way body has we have in the US, that one is called the council. The body will be in charge of people that live in prisons. It will be the correctional staff to the people that to be this body to take care. They are providing it. That body will be well funded to carry out this task. The federal government and the state government collaborate. You have the NKS system. What they do is that the federal government contributes some amount. The state also contributes. The state will spend its money. Then the federal government will refund. Although one bank, also refund to the federal government eventually. So that kind of system can be adopted. So that we don't have the data bank of people that maybe the prison and this body continues to take care of them. Maybe for 2 years, they are paid the non-living prison space for another kind of stipend. You cope. So that after 2 years, we believe that 2 years clearly use society such a way that you will not have much people again. So these are issues that I've thought about, which I feel I should share. The issue of congestion of prison is there. It has been the most that it is. We in our office, we are brought we are disturbed every day that they are waiting China inmates constitute the higher about 70% of people in the prison, in the corrections. But what we do now is that we have taken the decision that legal advice must be taken 2 weeks before it's out. Likewise, information and prosecution will be accelerated. These are some of the plans we have to ensure that we don't kill too many people in their waiting trial section. Because if you talk about prison congestion, the waiting trial means that people the case, not even the regular, the normal committed people. I mean, yes, not even them. And then as matter of fact, they are better taking care of the inmates, they are better taking care of. But the ability of inmates condition is worse. This is why we need to treat us, reduce the population.
Thank you, Mr. Everybody, for your perspective at this point. We have taken a look, we're cutting it down because you are the DPP, so you are also speaking policy of government. All right, we'll take it. What's your perspective on what are your public expert of concern? I know you are a defense counsel and you have your own ideas on how all these things will work out. So, rehabilitation, integration, what do you have to say? You have 10 minutes.
Thank you very much, Ben. I'm grateful. I would also like to appreciate the leadership of the Nigerian Bar Association for counting me worthy to be a panelist today. Thank you very much. Thank you very much. So I'll start by looking at the angle. I'll start by looking at the angle of the Nigeria Correctional Service Act, which is the legal framework regulating correctional services in Nigeria. It is no doubt, as the chairman of this occasion has said, that this act signals a shift from a punitive institution to a more correctional agency, because we've seen that mere incarceration with punishment without more does no good. So this act, as part of its core objective, rehabilitation and the integration of inmates so that they can be better in the society. And from the expectation budget expedition summary of the 2025 appropriation bill, a total of 183.6 billion was earmarked for correctional services. And when we look at the breakdown, it covers personnel costs, overhead costs, repair of facilities, feeding of inmates. But it is strange that there is no focus on reintegration of inmates. It is strange there is no focus on that. So it now brings the question: what does the government have for re-entry and reintegration of inmates to the society? Because we've seen that, in fact, some people will tell you that the real prison is when you leave the walls of the correctional service. That is when the real prison starts. They tell you that the burden of reintegrating into the society weighs more heavier than the iron bars that covers the four corners of the prison. And you won't blame them. When we look at the Correctional Service Act, it has provision for integration. This includes providing educational opportunities, vocational training for inmates to equip them and prepare them for life after prison. And the government has been doing fantastically well in this area. They use the system of the open distance and e-learning, which is adopted with the National Open University of Nigeria. We have so many inmates that are enrolled and even gotten certificates. And even most laudable is the fact that in year 2014 and 2018, inmates from correctional services, Enugu in particular, were the best students in the Nigeria Open University of Nigeria. So it shows that yes, they are doing this. The Act also provides that upon release, they mandate the correctional service to provide transportation allowance to inmates to go to their respective homes. Also, this Act, that is the 2019 Act, also provides that when they exhibit exemplary conduct, you give them certificates of good behavior, so that when they go to the outside world, the issue of discrimination is reduced. But I want to tell you that this Act is only fantastic on paper. It is progressive on paper, it is wonderful, but what about the implementation? There's a wide gap between what is contained on the Act and how it is being implemented. What we see nowadays is extremely different. What do we see? We see social stigmatization, we see social exclusion, we see discrimination, we see lack of opportunities, employment opportunities, housing opportunities, medical opportunities, educational opportunities, and what does this lead to? Recidivism. And they will say that with the current situation in Nigeria, most especially with the unemployment rate, an ex-convict competes from a position of disadvantage because he's competing with little or no education, no requisite skill, no support, and a criminal record. And when there is nothing to do, they go back. And that is why this thing keeps coming. And the government has chosen to ignore that aspect. What we see today, the practical reality is that when you are within the correctional center, you are a responsibility of the government. But when you leave, the time you transit to be stable in the society, who cares for you? No one, you're on your own. They will tell you what they share. In fact, it is as bad as the condition they give, the attention they give to convicts in the correctional facilities is different from what they give to their waiting trials. Because they will tell you our waiting trials are not their property like that. They are just using their space for the main time. But in reality, the same stigmatization that affects convicts also affects awaiting trial, even when at the end of the day, maybe after their trial, they are eventually discharged and acquitted. But that stigma is there. The society also rejects them, but there is no care from the government and even other stakeholders. Let me give some instances of this recidivism, and even in more particular, as nearer to us. There is a case of the 33-year-old Omishaki Sunday from Osun State. On Christmas Eve of year 2024, Governor Ademola Adeleke of Osun State extended a gesture of mercy to this Omishaki Sunday. This was meant to give him a clean slate from criminal record. But can you guess what happened? Barely days after, 3rd of January to be precise, he was again rearrested for having allegedly broken into a house and stole a plasma television set of worth 600,000. And what then happened, he was again remanded because when he got to court, his bail was vehemently opposed. Coming down to our environment here is the case of Simeon Martin, a 21-year-old Simeon Martin. He was released on the 1st of January after having completed his term of imprisonment because he was sentenced for drug peddling and theft. But what happened again? He was arrested days after, 1st to 5th of January, by the Amotekun Corps. He was arrested for the same offense of drug peddling and theft, and was again taken back. We see that when we look at this situation, although it gives a sore taste in our mouth, but then it also leads to the uncomfortable question that what then is the effectiveness of this correctional system? We see that it is not as effective as it looks on paper, and we all have a lot to do. We need halfway homes. We are all stakeholders. I know in Africa we have the St. Joseph, halfway homes. But we need concerted effort to focus on those areas. Every time we go to the prison, we give them slippers, we are even going on Thursday now. But do we care about the halfway home? When they leave, do we care about how they transition to the system? The government needs to do more in the aspect of reintegration. Counseling, parole should all be there. I don't think we have record of released inmates. I don't think we have designated officers of the correctional services that even call once in a while to monitor them. Nothing, they go their way. And when they have nothing to do, they go back. And even us, speaking as the angle of a defense counsel now, because they are our clients, we are their first interface. I think we also need to do more. We are in a situation now in the legal practice that because of the requirements of the Legal Practitioners Privileges Commission that requires you to have done a certain number of pro bono criminal cases for those we are in a situation now in legal practice that before you can aspire to the rank of legal senior advocate of Nigeria, you are required to have conducted a certain number of pro bono criminal cases. And because of this, you see his defense lawyers are even the ones begging for pro bono cases now. But I want to implore us legal practitioners that our duty should not end in the courtroom. Let's not end as providing legal aid services in court. Let us extend this duty to outside courts. let us try to call them, let us monitor them, even awaiting trials that are eventually discharged. Most times we just leave them there. Okay, thank you, I've done my case, I've done my work, and you move on to the next case. But we owe it a duty as stakeholders to also participate in this social reintegration process. For the cases, the pro bono cases I've handled, I've had cause to cater for welfare of ex-convicts after their release, because I no longer see them as ex-convicts. I see them as reformed individuals. Because if we are shifting from the polity to the correctional, it's either we are shifting or we are not. We should not be in the middle. My principal, Chief Wale Ologosho, SCN, God bless his soul, there was a time we had a client, she was incarcerated for over 15 years. After her release, she had nowhere to go. My principal had to personally accommodate this woman for over 3 weeks. And even we in the office, we were saying, okay, this woman, are you not scared? They said, no, we should not discriminate. Because when they have nowhere to go, it is even as bad as when they leave on the day of release, they start calling you, barrister, I don't have transportation allowance. And the Act provides that the correctional service should take care of this. But it is not being done. Once you are released, they tell you to find your way. And when you go to the society, what do? You start hustling, looking for money, looking for theft and all that, and any offense, just to survive. It is now a game of survival of the fittest. So I want to implore also, and also the bench too, also has a role to play in reintegration, rehabilitation and reintegration. Punishment should not just be focused, sentencing should not just be focused on incarceration and punishment. Let us also look more to the aspect of parole and community service and all that, not just incarceration. We all have a role to play. It's not the duty of the government alone. We are all stakeholders. Thank you very much.
Thank you very much, Ms. Dada, for that perspective. I think she has done some good job there. I'll be calling on Mr. Pedro. Let's have another view of this topic.
Thank you, the Honorable Chairman of this panel, my fellow panelists, and my lords, learned colleagues and seniors, all protocols to be observed. I am very happy with this topic because it is something that weighs on my mind a lot. When people are sentenced to correctional facilities, what becomes their fate? Usually, people will tell you that when a person goes to a correctional facility, by the time they are coming out, they are even more ardent than how they went in. And we really need to look into what causes it. Why is it that someone who was sentenced to a correctional facility for stealing, by the time he comes out, he upgrades to murder? What has happened within that period of time? What has he experienced? You will come to find that a lot of these people are traumatized. In fact, being in the position of a defendant for a criminal offense or a criminal matter in itself is traumatic. Now being sentenced, it's even more traumatizing. And then you go in, and instead of being rehabilitated, you encounter severe punishment, even worse than you have imagined. Your fellow inmates will first beat you up from a lot of stories we've heard, welcoming you, making sure at first you are subdued. You don't have the courage to even speak against whatever it is they are doing. Then who are the officers in these correctional facilities? Do they have the training? Do they have the capacity? Do they have the knowledge required to even assist these people? A lot of times, I know the Ministry of Interior, they do a lot to make sure people that are being employed in those facilities are those who are trained and who have knowledge. But you come to find that when they get in, it's like the system suppresses them. If you can't beat them, you join them. You downgrade the inmates, you insult them. They are not well fed. In fact, people will tell you, go and eat beans. When you eat beans for 3 months and you come out, you will know what has happened to your health. Should prison ideally be associated with eating beans? It should not. But people will tell you, you will go and eat beans. Go there, 2 portions of beans. You know, we need to look at these things properly and carefully. It should be a rehabilitation center. It should be a place that where someone goes, they get educated, they are more enlightened. The psychological aspect of it is something that must not be underestimated. It is very important, very core. A person's mind determines who that person is going to be, determine what actions that person will take. If a person's mind is messed up, whatever that person does is going to be a mess. But when people go in and they are met with officers who receive them with a heart of love, with a spirit that I want this person to change, I am interested in this person's life, I want you to do better, then you will find that the rehabilitation centers will be better. When they are not treated poorly, when they are in these facilities, when they are well fed, where their living is good living condition. Of course, it will not be perfect like in your private house, but it is humane enough. Even the Constitution guarantees your right to dignity. When you are in a place that you have dignity, you are treated and seen like a human being, not as an animal. You will find that when that person comes out, the person wants to do better. And also, sentencing, it is also to, not just to rehabilitate the person. It is also a form of punishment, which means you must not go there and be expecting to be living in mini London. Because the person will say, my condition outside was worse than this, I might as well do everything I can to go back there. There must be a balance. And this balance is key. Now let's talk about reintegration. I would like to ask a question because I like to get personal when I have the opportunity to speak with people. If someone comes to you for employment, maybe for a driver position, and the person tells you, I've been incarcerated for 15 years, what will your first reaction be in that moment? You panic. I said, yes. Your first reaction will be panic. Perhaps you have been speaking with that person for the past 30 minutes. You had no reason to worry until you heard that that person had been incarcerated for 15 years. Then you start asking, what did you do? Stealing. I stole television, I did this, I did that. If I give this person opportunity to drive my car, I will find my car in Bauchi in the next 2 days. Then you start getting afraid. Someone comes to you to interview for a position of a housemaid. And then, this person wants to be living in my house. You've been incarcerated for 1 year. No. What will my children learn from you? Is my life safe with you? Even families deny their brothers and their sisters. Let me say in Yoruba, our lemon. This is very fundamental. When that person is coming out, even the family rejects the person. The society rejects the person. The person is stigmatized. How do you expect that person to do better? How do you expect him to even think better? How do you expect that person to heal, to recover, to be useful to himself and to the society? A society that has already rejected him? A society that is already against him? How many of my dear colleagues here can hire an ex-inmate as a clerk in his firm? We need to bring things personal, bring it close to home. bring it close to yourself, because it's very easy to talk about statistics. It's very easy to talk about laws and enactments and others. They are very theoretical. We need to make it personal. We need to make it relatable. We need to educate people, educate members of the society. If you condemn somebody because that person had been to a correctional facility, then what is the whole point of calling it a correctional facility? It means you believe the person has not been corrected. It means you believe that person has not learned. We need to educate members of the society to know that these facilities are there for a particular reason. For people to be reformed. For people to go there and learn to stay away from crime. While people are in correctional facilities, it is expected that there should be vocational trainings for them. It is expected that there should be counseling sessions for them. It is expected that there should be fun activities for them, sports, for example. When a person is idle, it's just like the saying, an idle mind is the devil's workshop. The only thing a person in a correctional facility has abundance of is time. And when your time is not occupied, your mind wanders. Your mind and your imagination, it widens, it gets broad. God forbid any one of us falls sick, but imagine being sick and you're at home for 3 days. Someone who is active, who goes out every day, you're going to work, you're interfacing with clients, you're going to court, and then you're sick and you're idle for 3 days, just in your room or in your hospital bed. You know what happens to your mind just within that short period of time. Now look at someone who is idle and has nothing to do for a longer period of time. They devise very devious schemes there. Because different kind of things will be coming to them. Oh, what mistake did I make? I should not have carried AK-47, I should have used a pistol. Oh, when I was going, I should not have used a colorful car, I should have used a black one. They will start thinking of how to commit the crime better with hopes that they will escape. Because their mind is free, there's nothing they are thinking of, there's nothing they are doing. But when their time is occupied with studies, they are learning skills, they are having little fun engagements to do sports, football, music, some other things like that, and they are being treated properly. They'll be like, oh, when I go out and I do better, I will not need to return to somewhere like this. And we find a lot of people commit crime. Mostly, if you look at it, poverty. They are not educated. If you look at the statistics of crime, you see a lot of them are uneducated, unemployed, no source of livelihood. And they are roaming about the streets. From there, they start to mingle with people who are already in that line of crime. And because they are trying to look for a better life for themselves, they engage. And then when they get to the correctional facilities and they come out, they will tell you, I've seen everything. Then they get even more bold. We are not saying make the correctional facilities palace, but we are saying it must be to an extent and to a level where someone who is coming out with less trauma, is coming out with more to offer. The person is coming out better than how they went in. What can be our contribution as legal practitioners? Like Ms. Nika said earlier, it should not just be limited to the courtroom activities. If you ask how many lawyers have ever visited prison before, apart from I'm going to see my clients, you will realize that it's very little. Even you will find some lawyers are even afraid of going there. But if you go from time to time, relate with them, how are you doing, what is happening, what is your situation, you look at the environment, you will even be inspired to advocate for reforms. You cannot advocate on what you have no knowledge about. When you have knowledge and you have ideas, you will be able to advocate better. And when you're given the chance to sit in panels where reforms are being discussed, you will have very good things to contribute to it. So I would like to urge us all today, let us not just limit our advocacy to court. Let us go far to make sure that when people are sent to correctional facilities, they are there and they are truly reformed, and that when they come back into the society, we welcome them with a heart of love and warmth. Thank you.
We have a lot of applause for that. Thanks for coming in. I just got to know that you were present at the last minute, and you have done so much. I want to appreciate your perspective, and I will give you a recap shortly after everybody has spoken. I'm going to introduce Mr. Ademola Adeyeye. He's a very peculiar person. He has a story to tell that speaks exactly to the topic that we are discussing. So you have the floor. We give you 10 minutes to let us know what is going on in your mind regarding that which we are discussing.
Thank you, sir. Let me start with this. Standing on the existing protocol, I really appreciate this opportunity, and I salute this great step by the NBA Akure Charter. I greet the Honorable Senator Odeola Jumoke and every dignitaries sitting here. I want to give an unquantifiable appreciation to Almighty God for this opportunity, because without Him, today will not be happening. Let me start with this. My story is Amazing Grace, because I went through every section of incarceration, awaiting trials, death row, and life imprisonment before I was commuted to 10 years. And my story will not be complete if I don't appreciate the kind gesture of, in blessed memory of the former governor Rotimi Akeredolu, that commuted me from death to life when I wrote this book on death row. It was launched in the prison, right in the facility in Kirikiri, Lagos. I won't say this. The judiciary is doing a lot, but there is still a lot to do when we are talking about rehabilitation and reintegration. Honestly, I started from the punitive system of prison before it was changed to correctional. I started writing books when a pen is an exhibit behind the bar. The writing material is an exhibit, believing that inmates can injure themselves with pen as a sharp object, and they can also attack prison officers. So we're not allowed to use pen. So I stylishly approached this man in front of this book in his office. His name is Oluseyi Oduton. He's now a retired controller. Some officers are actually retired, but they are not tired. They are still useful. I met him in his office. I said, sir, I knew this thing is against your work. But sir, I knelt down in his office. I said, with due respect, I discovered I have this writing talent and I want to pick it up. I discovered I could write meaningful words in the prison. When I was outside, I was gallivanting around. What brought me to this was from political thuggery. I was on my 200 level in Adekiti, now EXU. I ventured into political trouble, and that was how I lost my grip. So I told him, I said, please, I discovered myself from here that I want to start writing books. He looked at me, he said, boy, as well as I want to help you, I don't want to lose my job. But the only thing I'm going to tell you is, anytime I come across a pen from you, I will seize it. If you know how to go about writing your book without other inmates having access to the pen, or I as an officer setting my eyes on the pen, well, no problem. But once I come for searching and I discover you have a pen with you, I will seize it. So I got a pen and an exercise book. I started writing, and in that process, I was healed even while I was awaiting trial. And I've been determined that come what may, I will use this opportunity to rewrite my story in a golden pen, despite knowing the fact that I have held. While I was behind bar, I had this mindset that one day, although by the time I came out, the victim in my case was late, in person of Mr. Ajitumobi Shile Motors in Ondo Town. And I had the mindset that I'm going to visit him to still apologize despite serving the terms. I had the mindset that I'm still going to visit in blessed memory of Justice Akeredolu. I'm going to visit her and also appreciate how God used her as a tool to reshape my life. I see the journey that I went through as an instrument to fine-tune how God wants me to be. Anywhere I get to, I'm not ashamed to identify myself as an ex-convict. I usually tell my fellow inmates, we call ourselves teammates behind bar, that I am number one Eleon, as we usually refer to ourselves whenever we're I'm number one Eleon in Nigeria. I don't know of other countries of the world, because I decided that when I'm out, I'm going to stand my ground to do what is right. Concerning stigmatization, it's not easy at all. I must be frank and sincere with you. Even my own family, none have set their eyes on me since I've been released. I won't be surprised. My family, they only talk to me on the phone. At the time when I discovered that it's playing on my mental health, I decided to cut off from family and focus on God, who is my father and my mother. We cannot do without mentioning the impact religious bodies are contributing to reformation. National Open University, Pastor Ige Adeboye played a lot of roles for National Open University to come into maximum prison Kirikiri. And where I said the judiciary in Ondo State have a lot of role to play, I must be frank and sincere with you. I'm talking from experience. Yesterday I wanted to jot some things down, but within me I felt, what am I writing down? I'm talking from what I went through. It is not what I read in the book. It was in the prison I discovered that the biggest institution in the world that nobody prays to go there is the prison. Because there are some things you will discover in the prison that you cannot discover out here. We call it behind bar, another world. It was while I was in the prison I discovered that the best time to discover one's potential or to ruminate. It is when you isolate yourself from the society. That is why some great men of value, you will discover that they disappear from social media, you don't know anything about them for some time. They are removing their wings like an eagle that is about to grow a new wings. So I won't say this. Unavailability of jobs for ex-convicts is one of the challenges why recidivist is playing a lot of backwardness in all the jobs, judiciary system and the correctional facility are doing. Because I personally myself, I came out with a burning zeal of becoming an entrepreneur. But when I came out, what I met took those zeal, took it to like 40%. Because while I was in prison, I took every opportunity that comes my way. As I'm talking to you, I'm a professional baker, certified by Honeywell Flour Mill. I learned it in the prison. As I'm talking to you, I can produce 5 different things: test codes, emulsion, satin, glossing. I learned it behind the bar. As I'm talking to you, there is a life-changing program called Joy Bringers Character Training Class that deals with human principles of life courses like anger management, purpose-driven life, character building. To mention a few, I was the coordinator for 5 years. I think I spent 6 years awaiting trial, 5 years on death row, and I spent 4 years on life imprisonment. I want to let you know that in the process of my journey, I was a leader, a provost, a head of inmates in a cell of about 199 lockup in awaiting trial for 2 years. And while I was on death row, I was the provost on death row for 2 years for inmates of about 52 lockup. And under my watch then, there are high-profile inmates that when we make mention of them in the federal level, everywhere we shake. High-profile inmates, kidnappers. You can mention them, assassins. You can mention them who were together in the same cell, and I used to be their provost. Even whenever they have issues between themselves, I will be the one to settle cases for them. I want to let us know that in Ondo State here, I was in awaiting trial for 6 years without having opportunity to even read a newspaper. Why I said there is a lot of work to still do. No opportunity of formal education behind the bar while I was in Ondo State here. My 6 years was just nothing to write home about. Until I was transferred to Lagos after my sentence. That was when I decided that I don't want to continue in what I was studying while I was in UNAD. I want to study mass communication. Although I have the plan of going into journalism, but for personal reasons, I decided not to go for journalism because I decided to study just mass communication. I want to let us know that I sat for GCE thrice. My first GCE, I have 5F9 as a result of not having opportunity for education for 6 years in awaiting trial. You can imagine a student that was once being 200 level in the university, now sitting for WAEC, having 5 F9. I was not discouraged. I sat for the second one, and this time around, our result was 6 then. They said there was a malpractice in Ikoyi prison. It robbed other correctional facility. So they didn't release our results, and thereafter I sat for the third one. The welfare in charge officer told me, come on, this is your last opportunity. Once you waste this opportunity, you will not have the opportunity for education again in the facility. So I started reading, burning candles. I said I must make it this time around. And by the time my results came out, I had 7 credits, including my mathematics and English. That took me for my mass communication, and I can tell you, I was in my 400 level before I was released. In fact, just a semester. And as I'm talking to you, I'm true, a BSc holder in mass communication, National Open University. I want to end it with this. There are a lot of inmates behind bar that are done with their degree. What is the essence of having a degree and still behind bar? Some are even doing their masters. In fact, I'm even in the list of the brainer behind the bar that are opportune to come out. There are still a lot of people that are highly intelligent than I do. Because I want to let you know, we have a lot of things, a lot of way to go. At times I sit down to look at humanitarian resources that are being wasted behind bar, while we have a lot of lands. Most times when I'm traveling from Lagos to Ibadan, I see hectares of land that are just there. When we have European countries that don't even have fertile soil, and we are shouting of hunger in Nigeria, and we have a lot of lands that can be cultivated by the correctional facilities through the Ministry of Agriculture, and there will be a lot of foods. And inmates behind bar, we have something to fall on by the time they are released, because stipends will be paid into their accounts. I can imagine spending 15 years and coming out with nothing. The day I was released, I was just having 2,700 naira with me. If not for the church, Abundant Life Gospel Church, that decided to employ me without even waiting for my certificate. They employed me as a video personnel. This is my ID card, Abundant Life Gospel Church. If not for them, who would have given me an employment as an ex-inmate? I would have just been languishing in the street. Despite that, I've seen other inmates that came out from the prison that have met me at the time. Things were difficult. Come, let's go back to crime. Let's go and rob. I tell them, come, that used to be my past. This is me. I'm not doing such. And at the end of the day, I ended up to hear that they've been arrested in different locations for committing crimes. Some were even killed at the spot. Not to take much of our time, I want to let us to know that there is still a lot of work to do. Thank you. God bless NBA Apparel Chapter for this great opportunity and this privilege. I appreciate it.
Shall we continue the applause?
Thank you.
This is a very remarkable person, and the ovation is standing, and I think we start for you as well here, to acknowledge courage, to acknowledge. Thank you very much. Thank you so very much. We appreciate your story. I started by saying you have a peculiar story. We actually started the right schedule. Otherwise, we could listen to you the whole day long, because you present a personality that is different from the ones that we see, and a perspective that is real. So you are welcome. Let me tell you, people say somebody is an ex-convict. Of course, my understanding of ex-convict means somebody who was a convict but who has been released from conviction. It's not about somebody going to prison and coming out at all. But it's a different thing exactly. Because you are telling us from direct experience what to go through. I want to make a short recap of what they have said before we throw the questions out for comments. We started with Mr. Olubodu, and his main concern was about the attitudinal and the funding profile of the present correctional center. In his view, it is insufficient, and particularly that there's a lot of stigma, just like we are all associated with people who have interacted with the correctional center. Of course, he has recommended in-cares, and I think you still have to give some other insight as to how in-care used in America is applicable and how it can be adopted in Nigeria within the profile of our current state. And you told me it's a social protection part with the people, and I believe that you have done so well with it. Mr. Mutayo started by reading out the instruments, the papers, the articles and acts that defines the paradigm shift from prison to correctionals. And try to tell us that none of these, there's substantial provision for reformation, there's substantial provision for the integration of ex-inmates into society. But she also doubts whether all these are done in reality, and she believes that there's a lot of trauma associated with being an ex-inmate, whether you are guilty, not guilty, you have served your time, or you have been pardoned. There is a lot of trauma that is associated with your integration back to society. And she just dropped it by the hint that there is no data associated with those who go and those who come out. We have a lot of guesswork, even at the top management level of the correctional center. There's a lot of guesswork that is associated with data. We need to be very realistic with it, and we need to leave the areas of guesswork to real facts. Mr. Akinolu emphasizes the refusal of society, particularly to accept anybody who had interacted with the system. And I quite appreciate you for that, because in my town, where I come from, if you are arrested by the police, you are gone to prison. That's it. I'm a leg on you. If you have been arrested by the police in my village, you are a prisoner, and you need to wash that away. Even up to allow children to play with you. You know, honestly, if you are too used to going to police station, my parents' house was located very close to the police station, so we were always looking at when they were doing police station. Sometimes, whenever we have some child, we go and watch. My mother had to call me at the time that don't be used to police station, no, so that the prisoners will not just point at you. You know, there is a lot of stigma associated with that. You also talk about whether or not the present correctional officers here have the capacity to be able to do some correction, because they were employed within the profile of prison, detained, punish, do this. Suddenly the name change, suddenly the law change. But then the personalities involved have they changed? So she doubts whether or not we have enough officers who can work on here. She's almost suggesting that the correctional centers should have psychologists, to have other categories of officers who can be a halfway between detention and reintegration back to society. Now, the story of Mr. Adele, you all heard the story, and without asking for too much, can I ask for another round of applause for this young man? I find it difficult to tell him that he has exhausted his time because he was presenting something that was unique. I want to congratulate you again. I remember during my travels, I told myself that I was going to pray for 3 days. I will not leave the upstairs in my house, then I will not even step out. You know, women will like that. My wife like that. I said I will not even go downstairs in my house. When it was 5 o'clock of that day, I couldn't stand it again. You know, I said, no, I'm going to feed this room. I will pray and sleep, wake up. I was doing it 12 o'clock, 1, 2, 3, when it was 5. One of my friends came and said, that what are you doing this room? Come on, John. I said, just leave me alone. When it was 6 o'clock, he didn't know, I couldn't stand it. I had to just break it. I made the promise, I have broken the promise. See, I'm using that to interpret what you go through. I imagine how your day look like. When you wake up in the morning, you don't have a job to do. The same people, the same command environment, you are expecting the same hour. And the routine is the same. And you have to do this for 5-6 years. But sometimes, maybe not up to that, but if definite number of years, it takes courage for your mind to still be safe. Ordinarily, your mind should have been messed up with. That you came out with the idea of writing a book. God has a purpose for you. And I pray you don't lose that purpose. Yes. So we will still have the opportunity of making the actions, but I think we are going to have people speak now. Yes. Judicial discretion. So many hands are out there. So we are going to entertain. I will give Mr. Dayapilaya, senior advocate, a trump card. Different from every other person because it's your organization right now. Baba Are Agaye, I give you one. I am looking at Mr. Dan. So I take Mr. Kilanja, Agaye, Dan. Oh yes, I have to be gender sensitive. Dr. Adegoye, Aderosoye. I can see you because of your peculiarity in the Ministry of Justice. But most of those people, half of those people are the ones who brought them there. Yes, yes. So I'll speak to you. So let's start with Mr. Yes, you all have to listen so that you will make your reaction later. Yes, Mr. Kilanja, please. Nancy. Hello, sir. Excuse me. Great my Lord, I honestly believe that short commentary, please. This is an eye-opener for us all, and I want to take it a step further from where I stopped yesterday. My honest conviction is that if there is a time for us to be pragmatic, practical, and purposeful, this is one, and this is a very big opportunity for us to make the significant difference that we all need. This gentleman, God bless and be with you continually, has opened our eyes to a stark reality. Speaking for myself, that it had never crossed my mind. I've always been of the view and advocacy that he mentioned the issue of farmland, and I was telling our guys here that look, I honestly wonder what is the problem with our leaders. With due respect to them, it shouldn't be a rocket science for people to know that all these lands lying far away and here, the people can turn them around. But the important thing here is that I want us to be practical, and that is that NBA Akure branch we can pioneer this in Nigeria. You know, please, right now, let us have a committee that will be exclusively saddled with the responsibility of attending to this issue in our society. Crucial and pivotal as it is, by all means. Please, I'm calling on them, with due respect, I'm calling on the chairman of the branch. You know, we need a committee, and what will be the primary focus of the committee? The committee should be to interface with correctional facilities at the national level, not even at the state level, at the national level. We have the capacity to do this, and I want to believe that the Ministry of Justice should be very, should be highly present, you know, on that committee. I mean, the president should be highly present in that committee because we are going to make a between us and the state government. You know, but beyond that, I want us to really appreciate the enormity of the problem, pardon my language, of the disaster that we are faced with. When it is brought to mind that it is not everybody that is inside that place that actually merits to be there. You know, permit me to say this in Yoruba, they say Oyiyeye ni Ogun, Taise Lopo. Now, in rounding off, let me just mention that so many years ago, when I was just very young in practice, I had the privilege of appearing for some university students. The difference being that they were involved in activism. They were arrested. Kwara State police command. They were arrested. At that time, it was just student unionism. But strangely enough, one day, it was not a time when we have a GSM. I was at the police headquarters because I had a friend, a senior friend, who was the head of the CID of Kwara State Command. I used to go and make phone calls. I was there, he was on phone. The man is late now. He was on phone. I just started there and say, no, I can't do that. Professor, I cannot do that. By the God that Kasa will not allow me to do that. So, after I said, I'm done, the conversation ended. He dropped the mantelpiece. I said, Dayo, can you imagine a professor at the university was asking me to frame up these children as armed robbers? It was a personal thing, not, you know, at the end of the day, it was just because that man had the pure conscience, the godliness, not to accede to the evil request of the professor in question. All said and done, I think they were able to reach out. Those students, they were there for weeks. Even when eventually they were charged to court, the man only charged them because he said they could get a superior person or another person to frame up this season. I'm sorry, I'm taking a little time. Eventually they charged them to court for breaking. They said they resisted police arrest. That they destroyed padlock, university gate padlock. They come here. That was what they charged them with. But the point is that if not for that gentleman who was godly, they would have been taken to court for armed robbery. They would not have been released from where I was. Even when the charge against them was extremely flimsy and frivolous, they were still there for weeks. Now my point is that as of today, at least not to me, two of those students are medical doctors. One is two rather are lawyers today. But the point is that if not for the intervention of that body gentleman, God rest his soul, today would have been saying something different. So my point is that there are certainly so many people out there inside there who do not deserve to be there. So this is why it becomes more imperative for us to know that we have a disaster on our hands that we must address and decisively deal with immediately. So I plead with the chairman of the branch and the senior advocates here that to please let us do it immediately. We must not go beyond today. Let us set up this committee and let us start work. If there is any way you want to involve me, all ready. I'm grateful that God bless us.
Thank you very much, Nancy. Yes.
All protocol duly observed. I'm Chief Barrister Akole Unobudu. One of my points is that I'm looking at a situation where a single person will not be at a correctional home. There will be no single person in the correctional home. And I believe that it's possible. How is it possible? We are in a very rich country where we have money. The approved budget of those states was 600 billion. And Ondo State government is asking for another 500 billion as supplementary. I want to say that out of the former billions approved, this money was given out to people. If jobs are created, if people were allowed to go into family, if people are engaged, definitely there will be no stealing, there will be no armed robbery, there will be no kidnapping. Yorùbá says, ọwọ́ tó dilẹ̀ ni èṣù ń lò. Why are we not taking part of the money to create jobs for the people of Ondo State? Why are we not giving money to people to go into farming? Why are we not encouraging people to be busy?
Thank you.
That's number one. Number two, yes, we have to go back to the values of our society. Values of our society. When I was young, I was in Nigerian grammar school between 1975 and 1980. There was a teacher there, Mr. Bayodo of late memory. He will call us, we the Agogo people there, and tell us that, please, you people should be very careful. Rántí ọmọ ẹni tó ń ṣe. You should not spoil the name of your family. And I know that is how it is in Imeri. That is how it is in Ishua. That is how it is in Ilaramoki. I want the government to establish a department that will be preaching about how we should be talking about how people should not be committing offenses, how we should be sustaining our names. Those are the things I want to happen. And aside from that, I want to say that these correctional homes we are talking about, the people that are there, some of them are not supposed to be there. We have people that are stealing billions of naira. I believe that if we take $1 billion and use it to create jobs for people, this society will be good. All these problems will not be there. Let those that are stealing, let them go to correctional homes and not those that are stealing a tuba of yam, that are stealing a tuba of yam. The last one is that, with the greatest respect, I don't mind I don't bother to be precise. And I want to say that most of these problems are being created by our magistrates. Some of them are so sentimental. Why? Because there are some very simple and available offenses that a magistrate should say ordinarily, I will grant bail to this person. But they will not do that. Even the parents will be there, they will be ready to take those boys that committed ordinary simple stealing, housebreaking, they want to take them on bail, but they will say no, based on sentimental reason. Because my sister was once, her house was broken into, but the yam of my brother was stolen. As a result, we will not grant them bail. Most of them now, 100 of them are in the correctional home now. So let us beg the magistrates and some of the Thank you very much. Thank you very much. Thank you very much. We need to just proceed. The idea is for you to make comments. We don't want to throw stones. We don't want to throw out. We just want to be as civil as possible. No, I didn't say you should go there first. Go to Mr. Dan. Be very brief, please. In your comment or question, let's be very brief.
Thank you, Mr. Chairman. My first comment is an observation. When you look at the theme of this law week, it includes gathering of stakeholders. It is quite unfortunate that the least stakeholders that could positively contribute to the discourse at hand are not here, particularly the prison officers. The officials are not here. It is quite unfortunate. Next time a program of this nature is being organized, I will encourage the planners to organize and invite holders, prison officers of NDA, police officers, what have you, they ought to be here. That being said, my second comment is contrary to what Chief Agaye has posited. To me, the root cause of this problem that we are encountering is lack of adequate and sufficient prisons. You can call it correctional homes. But for me, I believe we should discontinence with the idea of decongesting the prisons. We should build more prisons. We have people that ought to be here. The gentleman that just gave his testimony this morning was privileged to have this experience because he was not part of the prison decongestion. If he had been removed from the prison walls within 6 months, 2 years of his incarceration, maybe he had a political godfather, he wouldn't be here to share this story. He would have gone back to the street. He would have gone back to political thuggery. He would perhaps have been killed. We need, when we are talking of ex-inmates coming back to, having been reformed, it takes process, it takes procedures. It is like talking of decongesting the Nigerian law school by graduating people after 3 months. Let them pass through the procedure. If somebody is convicted for 10 years, let them pass that sentence. Build more prisons. When we started as practitioners in Akure, we had only 4 magistrates in Okedabe. My Lord, Honorable Justice Kolawole was at not 1 to 4. Before you will see another magistrate court, you will get to Owo. After Owo, you will get to Ikare. But now we have hundreds of tens of magistrates who have jurisdictional power to convict. Where do you want to put these people? Build more prisons. And this prison decongestion
Let's round up.
Yes, it started as a political challenge. It started as a political challenge. They wanted to favor their people, don't bring them out, or let people continue. When I started practice, within the first 3 years, I was given 10 emails by the federal government to, as a part of this prison decongestion. Andrew Akaya was the Attorney General then. They paid me, they said they would pay 300,000 naira per inmate. Then making 3 million naira. They paid the first 1 million naira into my account, and I went to the prison.
Our time is short.
I
think we just have to round up.
Thank you so much.
I appreciate you.
I'm suggesting that we build more prisons for information to take place.
Can we have a round of applause for him? Now, I will accommodate Mrs. Falowo, but then we have not had anybody speak from the judiciary, and people have talked, so I will, my Lord, we have to speak. But then let's go to Mrs. Falowo first, then we can round up the session. No, gender, yes. We are speaking to gender.
My name is Helen Falowo. I will announce myself as a prosecutor in the Ministry of Justice of the State.
Okay.
Now, as a prosecutor, we have empathy. We have a primary assignment. Now, it does not mean that we hate the defendants or the inmates. Some of us have even gone out of the way to extend charity to them. In fact, people wonder, you are giving them this, you are giving them that. At the end of the day, you will prosecute and ensure that they are convicted. But the issue is that my primary concern now is on the postal homes, postal institutions, and women in prison. There are some children that go to prison, minors or juveniles that go to prison, the postal homes, and come out hardened criminals. There are no facilities there, especially the one at Ondo Road. They don't even go to school again. They are to post teachers there, teachers don't go to report there. If you donate things to them, it is the people there that will collect the donation and not give the children. We are saying this on paper. I know that the NBA branch now are trying to, gather some things to go and give inmates. I bet you 20%.
Thank you.
That is it. Now, women in prison,
please
so
just
they go there without children, but they come out with children. Who are those impregnating them here? Where are these children? Some of these children are taken to the motherless babies' homes. And the women come out and start demanding for their children. We don't know those who are impregnating them here, they know themselves. But unfortunately, they are not really here.
Now, thank you very much. This conversation can continue.
Thank you.
Dr. Adeni sorry I keep missing it. Yes, I called you earlier. Let's summarize it all. We have 10 minutes and we have 2 minutes to eat.
Thank you, Lord.
Yes.
Well, permit me to rest on the already established protocol. Well, actually, I have two questions. The first leg of the question has already been taken care of by Anderson, Mr. Akina Aisene. Now, the second leg goes thus, having listened to the discourse for today, and they are making links to the chief for this year's law week. I want to channel my question directly to Mr. Adeyemi. We have listened to your testimony, and it's really touching. It's the most genuine testimony I've heard in recent times, and I believe that God has actually.
Please, I think you need to take that question from me.
Yes.
So that I can listen.
Yes, I'm going there now. Listening to your testimony today, and they're looking at where you are coming from, finding yourself properly in society. Do you feel that if the inmates there that know what they are doing, of course we know that some people there that they are not challenging any cause to even be integrated into society, but have understudied the ones that are serious in being rehabilitated in society, that are taking every opportunity to educate themselves to learn one trade or the other. And if they are provided with emotional, psychological, and financial needs, for them to actually be integrated, do you feel that the society can be at peace receiving them without being unfaithful and ignorant? I want to listen to what James Aguero said, that if we are faced with this reality, someone is coming to you and saying, "Oh, I was an ex-convict," what would be your first reaction? And that was why I'm trying that question to you. How do we relate to these people? Looking at the casket of them that are serious, do you think we can be
Thank
sure?
you very much. My Lord, does it really pray? Yes. You may use the mic and make beautiful and wonderful contributions. Like Mr. Dan said, the actual stakeholders are not here, but I implore the NBA to make a special communique of today's session and pass it across to the stakeholders. And I make bold to say that in Nigeria we like the seats a lot, and we love beautiful names. As of today, let us be very, very pragmatic and realistic. We do not have a correctional center. What we have in Nigeria is a prison. We have a prison, not correctional system. So we deceive ourselves a lot. The name sounds beautiful, but the opposite is what transpires. And if we are very also realistic, convicts, the facility in those centers are sufficient for convicts, but the problems are they are waiting trial. They are waiting trial. If you go to Olokuta, you understand that there are enough spaces for convicts, but for awaiting trial, no. And the root cause, I will say, like let's say, a different view from that of Chief Abaye, not the magistrates, not the court. Right from arrest and investigation. In practice, we have clients that their files will be missing from the very day they are arraigned in court. Prosecutors will keep the files. As a legal practitioner, as a member of the Christian Lawyers Fellowship of Nigeria, we partnered with Prison Fellowship Nigeria. We got lists of awaiting trials. People who are in prison 8 years without going to court. Where are their files? Prosecutors kept those files. Ministry of Justice are also doing their best. But when prosecutors don't bring files for duplication, then you have so much awaiting trials. And I pray that we'll get you tried in this country one day. But above all, we do not have a correctional system. We have a punitive prison system in Nigeria. Thank you, my Lord. Now, I have been given an extension of time. so that our father, Dr. Olajumoke, will speak. Please give it to Dr. Olajumoke. He has a comment to make here.
Very much, Mr. Chairman. I want to congratulate the branch for this very successful session. Honestly, I do believe that it is imperative for us to already lead like we have in Burkina Faso, where the president of Burkina Faso has instituted a system whereby the prison can make restitution by giving back in one form or the other. If you still in Burkina Faso, easily the new arrangements that if you are renting, you are coming back, if something in the society, then instead of spending eternity in the prison, I think we should consider looking at that. I want to congratulate the panelists for what contributions. I want to congratulate the Nigerian NBA and
Thank you very much. I mean, I will have a applause for our very distinguished Dr. Olajumoke. Now, somebody sent this note in and said, how much latitude do faith-based groups have to exercise cognitive idea? Again, how much data and monitoring does the Ministry of Justice and other agencies have for policy implementation? That's the second one. And how much of best practices around the world can we bring into Nigeria? I take the questions again so that the rapporteurs can take very good note of it. Is how much latitude faith-based groups have to exercise informative idea? Again, how much data and monitoring does the Ministry of Justice and other agencies have for policy implementation? Third question, how much of best practices around the world can we bring into Nigeria? Well, as we ponder through these questions, I don't know if any of you have short comments, just one or statements to make. Yes, Mr. Alubadu, the question for Ministry of Justice is how much data and monitoring does the Ministry of Justice and other agencies have for policy implementation? So, in your Ministry of Justice, what's your disposal to policy information? And are you exposed to data?
That's a question to me, it's not clear. We're talking about policy implementation. In which area are we talking about? It's not clear. It's talking about data. If it's about data, we have data on what we do. We have record. If it's we are talking about policy.
My understanding of the question here is that, okay, my understanding of the question is that looking at the theme of what we are discussing, that is information, does the Ministry of Justice have a policy for implementation of information? Because don't look at the Ministry of Justice alone as agency of government to protect for government or to defend government. No, everything has to do with justice, from arrest to information. The duty of the Ministry of Justice in that situation, and I believe our system can. So how much data monitoring do you have in use of resources, or maybe for other agencies of government, for implementation? Do you have any?
We don't strictly have, because our core assignment is prosecution, and this aspect is strictly for the correctional services. So to that extent, I can't say we have data or policy in that respect. But then, as a ministry, I agree that anything concerning inmates that the Ministry of Justice can also.
So you believe if you have data, all right, would you recommend that you start with
Yes.
Now, I don't know if any of you will answer this. It says how much of best practices around the world can we bring into Nigeria? Best practices regarding it as a done abroad, can we import to Nigeria? Taking a look at the peculiarity of the Nigerian state. I think my Lord Dawson wants to say something about that.
Thank you very much, Mr. Chairman. Well, unfortunately, our leaders travel on a daily basis. We go outside the country. We see things the way they are done, but we don't come here to replicate them. In America, I'm aware that prisons are privatized. Especially there are some families in America that are known for that business. Mr. Lagan said we should build more prisons. Nigeria can replicate, can go out, see what happens here. Then you privatize prisons. How is it done? You have somebody who is rich, build a prison. In a year, we are giving you 300 inmates. We are paying so much for one person. That's the way it is done in America. So, that person is responsible for those 300 inmates throughout that year. And they keep renewing the contract every year. If you do this, I know many people will be interested in Nigerian love money. When they feel they can make money, then the only thing is just for the government to make give them an enabling environment. And give them guidelines as to how to go about it. We really need more prisons. We are not saying we are criminals to commit more offenses, but there is no way we can do, without seeing people committing offenses. So I would suggest privatize prisons. Let people come and build, set the rules, set the standards, and then give them inmates to handle as it is done in America. I've understood, I went for a study in America, and I studied out American prisons in line with what we studied.
I'm sure the rapporteurs are taking notes. Thank you, my Lord Dawson. Now, there was a question that was given asked to you. Please answer it that we can do the summary.
If I could paraphrase the question again, that how do I think some people that have gotten skills acquisition, education, if they have the opportunity to taste freedom again, that they can be useful to the society, can the society be rest assured and be at peace that they are going to contribute a very good quota to the society. Actually, to start with this, I want to make a proverb in Yoruba. They said, ẹni tí ó jìyà olóńgbò tani teacher àkọ́kọ́. I'm sorry to leave that because of the elders here. Anyone that have not tasted a kind of hardship in life will not be experienced to cherish an opportunity when he now has it. That is why they said we don't value what we have till we lost it. I don't used to value freedom till when I know what freedom is. Anyone that have never been to incarceration don't know what is freedom. Because when I have lost it, I knew the value, I know what the value is. So somebody who is educated or who have learned some skills, I can imagine myself having to train people on how to bake. I will do it sparingly because I practice baking. We have a bakery in Lagos, a bakery where we bake bread, and I used to be there. I can imagine I was doing it and they told us that they will be giving us salary. I told because it's an NGO that brought the bakery. I told the NGO, I said, I don't want salary, that I want to be working for free, because if I am to have this certificate outside, Honeywell told us we are not going to spend nothing less than 350,000 to have the certificate. And they brought it to me, the training and the certificate free of charge. So I think people behind bar, if they have the opportunity to come out and they are equipped, I think they will contribute judiciously to the nation.
Thank you very much. One last word. Now one last word.
Okay, thank you, Mr. Chairman. On the question of bringing international best practices to Nigeria, I would like to say that, as we know, Nigeria is a state party to some international treaties, such as the International Covenant on Civil and Political Rights, that emphasizes also on information and rehabilitation. And when we see what happens in other countries, inmates have access to other facilities as opposed to here. As Mr. Adeyeye rightly said, here you don't even have access to newspaper, not to talk of watching television. That means all you do is to just do whatever, just keep yourself, try to keep yourself not to be idle. But also, if we are integrating these practices to our country, we also need to look at our situation, whether as we have now, these practices will be best adaptable to us. We need to look at our budget, the budget appropriated to the prison. Can it accommodate what we want to accommodate, what we want to adapt? So we also need to consider that. Thank you.
So thank you very much for that. As we are rounding up because we have spent so much time, I want to thank all the participants. Let me thank you for giving me the chair of this particular session. I will begin with Mr. Kedu. Thank you for your insights. It's been very, very important. Mr. Olubodu, the work is going on. You don't have to present to look at, but I've had excuses. I will try to do, but I can trust you are very active. Now, Omotayo, you have been blowing grammar this morning. The grammar will not cease in your body. Now, like I said, we brought in a very remarkable person, and he has given us a very remarkable presentation. You agree with me? And I'm mandated by the managers of this session to request. I hope you are here, sir. Yes, for your book. How do people get access to this book? There's a lot of demand coming up for the book. Yes. You cannot be sorry. You need to provide. Oversubscribed.
To even put it online or go for a reprint. That's why I didn't have copies with me. I only have 2 copies. We printed 500 copies 2018, and we have to share to all inmates all across the prison facilities in Lagos. So we even have to ration it. So presently, I only have 2 copies.
Tell me about that. Now you'll be given opportunities to speak about your experience, and each time you are going to some places, you have a duty to have enough of the food, even in soft coffee. So as I said that, we have 20 months that I want to thank everybody, particularly the rest of everybody here for giving us the opportunity of this interaction. Thank you very much.
I believe we can appreciate my noble Lord more than that. Thank you, my noble Lord, for that incisive and robust engagement that characterized this second session. Indeed, it has stirred intellectual debate, and we know that it's something that everyone here will take home for further engagement. We also thank members of the panel for doing justice to this particular topic. Thank you so much. So my noble Lord, you are now in charge of this, your responsibility as per the second session. We are grateful, sir. Members of the panel, we are also grateful for your time and your deep sense of contribution to the topic. Ladies and gentlemen, we have to move at the pace of a bullet because we are already far behind schedule. May I respectfully recognize the presence of my noble Lord, Honorable Justice Akiton Osadebe. My Lord, you are welcome. May I also respectfully recognize the presence of my noble Lord T.M. Adedipe. My Lord, you are welcome. We also respectfully recognize the presence of my noble Lord Leo Olugun. Equally and of same significance, we also recognize the presence of my noble Lord, Honorable Justice Aki Binu. Please, members of the panel, who just stepped down, please, you are required for picture engagement, photograph engagement with the ESCO, please. With the chairman of the MBA. Thank you so much. Just before we move to the next item on the order of events, we are respectfully also recognize the presence of the following magistrates. Chief Magistrate Aderemi, please, you are welcome. Senior Magistrate Taiwo Lepi, please, you are also very much welcome. We are grateful to have you. We also have Bukola O.O. Mrs. Magistrate. You are welcome. We have R.A. Olumilu and Mrs. You are welcome. Of course, we have Ekujuni Mrs. also here this morning. You are welcome. Of course, we also have Adimoju. Thank you, man. You are welcome, man. Just to also recognize the presence of our able chairman as per the Long Planning Committee, Mr. Dayo Akinlada, Senior Advocate of Nigeria. We didn't do that earlier. Of course, we also have in our present this morning Fumi Adejumo, immediate past Permanent Secretary, Ministry of Justice. You are welcome. We also welcome one of our illustrious leaders at the bar who came in while the session was in progress, Mr. Banjo Ayunaki, immediate and accomplished chairman of the bar. Mr. Banjo Ayunaki, I saw you earlier. Thank you for coming. Please, members of the panel are just disengaged. Please, you are required for photo session with Mr. Chairman by this podium here. Please kindly come and cluster around the chairman for a photo session. Members of the panel that just stepped down, please kindly come forward for your photo session. We also have Mr. Rotimi Olorunfemi, past chairman of the MBA. I think I saw you earlier. Sir? Of course, we also have some of our senior members at the bar. Prince Ojubagu, please, we are sorry that we are recognizing quite late. You were here as one of the earliest persons to raise this occasion. Of course, Mr. Colin and Akoju. Thank you, very vocal and one of our leaders of the bar. Of course, we also have Mr. Benga Edema. He is the former chairman Osopladek. You were here with us yesterday. You also came quite early this morning. Thank you very much. We also recognize the presence of Prince N.K. Dari, former chairman, MBA Akure. Thank you so much. Of course, we have Mr. Barrister Adeyemi Tuki, former PS Minister of Justice. We also recognize DPP. Okay, former DPP, beg your pardon. Please, we are sorry that we are recognizing you late. Of course, we also have Barrister O.F. Akeredolu, also one of the senior members of the bar. Of course, we have Barrister Akeredolu Soyi, Women Forum leader, MBA. Okay. Former state lead, please also recognize your presence here this morning. O.F. Olumoloye, known chairman, also recognize your presence. Of Moloye, please also recognize your presence. Of course, we also recognize the presence of the classroom chairman. Please, you're also welcome. Okay, please. Please, we will now, because of time, proceed for the tea break session, and Mr. Anishafe will give us the schedule for the tea break. We will return in the next 20 minutes for the second session. Thank you.
Thank you very much. Please, this is the arrangement for the leaders of the bar present here, and my lords, and all the senior advocates. Please, you are to step into the executive chambers here for your tea break, while other members should go to the, there is a place that will be provided. Thank you so much. God bless you. We appreciate you. All the leaders of the bar, Prince Ojo Fagogo, Inokochu, the professor, join them here. Then my lords present here, please do step to the inner chamber. Thank you. Thank you. Please move to the, let all the members, aside from those that have been mentioned, please go to the, all former chairmen should go to the inner chamber. All former chairmen here present. Thank you. Honorable Edema, please join us at the inner chamber. Hello, Demo. Your worship, please. Yeah. And the magistrate will attend the announcement. When we resume, we
will do double portion. Ẹ má bínú o.
Give me love,
ably represented by the Honorable Attorney General Commissioner for Justice, Dr. Olukan Abraham Ajulo, Senior Advocate of Nigeria. And yesterday, we also saw the conferment of awards to some of our friends to the Akureba branch. And very significantly as well, we received here yesterday the former Minister for Aviation, Chief Femi Fani-Kayode, who delivered a mind-blowing speech concerning the state of Nigeria, particularly its status at the international level. And he did awake our consciousness to the fact that as a nation, at this very critical time, we must stand up for Nigeria, saying that Nigeria will only bow to God and not to an individual, regardless of status. And these sentiments were justifiably shared by all persons who gathered here yesterday. And we believe that this is only reverberating in the minds of all patriots who gathered to witness that speech yesterday. The theme for the Law Week this year, if I may remind you, is Nigeria, quest for utilitarian judiciary and rules for stakeholders. And yesterday, we had a very robust engagement presided by my noble Lord. And this morning we also had another session, also ably presided over by my noble Lord, and a stage debate, particularly the morning session regarding our administration of criminal justice system in Nigeria. And very more significantly as well, we had a man who had a practical experience of the policies that are formulated with respect to rehabilitation and reintegration of ex-convicts. And participants try as much as possible to draw a line between absolute release and the objective of abolition of criminal justice, as particularly demonstrated in the retributive justice system. And one of our finest, Mr. Oladan Ola, gave a contribution to the effect that rather than abolishing or removing all inmates, as postulated by Mr. Kole Inakoju, that the government should construct more prisons as crimes are growing in leaps and bounds. These are thoughts for further consideration. There are issues, contemporary issues that are raging, and we know that sooner or anytime, we would find a meeting point or consensus as regards these national issues. On this note, may I invite us to page 47 of our brochure, which is with the sessions for today. The second session, which is fourth business session, as can be found at page 47 of our brochure, is promoting electoral justice through legislative and judicial interventions. This topic will be taken by some of our eminent practitioners. Gentlemen, please, if you are here, kindly be seated as we kickstart the second session. Just before I call the panelists for the second session, may I respectfully also welcome back my noble lords to this second session, particularly thanking my noble lords for their patience. Yesterday my noble lords were here, and since morning they've been here, seated patiently, engaging the discourse when necessary. My noble lords, thank you very much. Of course, it seems that the central lexical item in the topic is judiciary, quest for utilitarian judiciary, and these have been subsumed under various themes which we are considering in the sessions. May I tender a very solemn apology to our magistrates who were innocently omitted while we were doing the recognition. Please, may I respectfully therefore recognize the presence of Deputy Chief Registrar Charity Adeyanju Mrs. Thank you very much, ma'am. Please, we are very, very sorry for recognizing you quite late. Of course, Chief Magistrate Adu Roja, Mrs. Please. In case I didn't pronounce that well, please, I'm very sorry. Please, we recognize your presence, and we are also sorry for recognizing you quite late. Of course, Olatusi Olayemi, Mrs. we also recognize your presence. Deputy Chief Registrar. We also have in our midst Deputy Chief Registrar Yunus. Thank you, sir. Of course, we also recognize Senior Magistrate R.A. Yusuf. Thank you. We are also sorry for recognizing you quite late. And we also respectfully recognize the presence of the judges at the Grade A Customary Court, Ayodada B. Please, are you here? Please, we recognize you in absentia. Agumbiade Umoru O. We recognize you in absentia. Ogun Moyero T. Please, we also recognize you in absentia. I know I was told you were, all of you were available at the first session. Falana T, please, we also recognize you in absentia. Adebayo T, we also recognize you in absentia because we know you were available at the first session. Odofin O, equally, we recognize you in absentia. I hope it wasn't a protest walkout. Oh, you are here. Thank you. Thank you, because I was looking forward to seeing your hands, so I need to be sure that it wasn't a protest walkout. Thank you so much. Of course, we have Odofin O. Are you here? Odofin? Oh, you are the one. Oh, you are grateful. Thank you. Rotiba X. Rotiba X. Okay, we also recognize you in our session. Ladies and gentlemen, now we have to move to the gravamen of this session, which is the constitution of the panel. This panel was envisaged to be chaired by my Lord Honorable Justice T.P. Adegoke, Judge of the Federal High Court, Akure Division, and land My noble Lord is unavoidably absent, and because nature abhors vacuum, my noble Lord, Honorable Justice Kola Wole, will now share this second session. Please, my honorable Lord, kindly come forward. Please put your hands together for my noble Lord. Thank you, my Lord. Of course, the lead discussant in this session is Dr. Remi Olatubara, Senior Advocate of Nigeria. He sent his apologies to the NBA that due to some extenuating circumstances he will be represented in this session by one of our savvy, progressive, and intellectual mind at the bar, Mr. Olumide Ogidon, Esquire. Mr. Olumide Ogidon, please kindly. Okay. He is the lead discussant. And have been reliably informed that all the areas to be discussed by the Nene Senior Advocate had been discussed with him, and so he will be given the latitude to extensively discuss this topic. Of course, member of the session as well is one of our finest in terms of public service. He was a former representative of Ondo State on the board of NDDC and former governorship aspirant. And of course, he was also former chairman on the State Oil Producing Commission, the SOTRADEC. Ladies and gentlemen, I present to you Mr. Gbenga Edema, Esquire. Put your hands together for him, please. I think that's is that a protest applause? Please kindly appreciate him, please. Mr. Elizabeth is telling me to say that. He's an expert in election litigation. Mr. Adema, thank you for coming. We learned that you have so much experience in election litigation and you do justice to this topic. On this note, ladies and gentlemen, I hand over this session to my noble Lord. Please, we are sorry for the fact that this session is not deficient of one person. Please, an apology to my noble Lord, Honorable Justice Demain. I just acted your face from him. I'm awfully sorry. I didn't know you'll be the auditorium since. Please, ladies and gentlemen, I recognize the presence of my Lord, Honorable Justice Demain. Please put your hands together for her. Also, just 5 minutes, sir. Just 5 minutes. Also, we are also with apology, also recognize the presence of one of our finest in Ondo State, former Attorney General and Commissioner for Justice in Ondo State, a very simple man by nature, Charles Titilo, Senior Advocate of Nigeria. You are welcome, sir. I've seen you quite repeatedly. I don't know why I feel to recognize you, sir. I'm awfully sorry. All right. On this note, we are respectfully, therefore, hand over the session to my Honorable Justice Kolawole for commencement. Thank you, my Lord.
Good afternoon. My lords present here, Senior Advocate of Nigeria present here, members of the noble profession, ladies and gentlemen, we are here gathered to discuss a topic which is very pivotal in our democratic journey. And it is promoting electoral justice through legislative and judicial interventions. All over the world, people pray for democracy. The difference between democracy and other types of government is the way those in government are put there. Those who are autocratic, they are leaders. Democratic leaders are leaders. The difference between the two is that the people are involved in putting democratic leadership in place. And the process of putting the live leadership in place is by election. For this to be credible, the electoral process must be credible. We have been on this journey since 1999. Thank God that we are still going strong. The system is not perfect, but no one will disagree with me that we can do far better than what we are doing presently. It is therefore important to look at the present situation and see how we can improve on it. The three arms of government are involved. Of course, the electoral body is part of the executive. The legislature has a big role to play in the efficacy of our electoral process because they put in place the laws that must be followed to have good elections. The judiciary interprets these laws. They too have a role to play in doing this. It's important to discuss this thing so as to improve our electoral system. Fortunately, this afternoon, we have two gentlemen who are very experienced in the ways our system works. And they have been constituted to this panel to discuss things. To my right is Honorable Edema, a seasoned politician, a lawyer, and a fastly experienced man in the affairs of men. He has had several practical experiences and dealing with the electoral system. I believe he will be able to share his experience with us this afternoon. To my left, he's a seasoned lawyer. I've had interaction with him in the past, and I know he has been involved in election petition for a long time. He should be able to give us his perspective on the topic we have at hand. We'll give them 15 minutes each speak with us. At the end, I will give an overview. I've been told that Barrister Olumide is here representing Dr. Olatunbura. He's here to present his paper. Of course, Olatunbura is a known person in this state. He has always been there since the turn of democracy in this state. He was a member of the House of Assembly, if I'm right, between 1999 and 2003. And I know he has been involved in so many electoral, in various election petitions. He wrote a very big book. I still have it in my library about election petition in Nigeria. I believe will be richly enriched by his paper. Let us start with Dr. Olatunbura, since he's reading a paper. Barrister Olumide, please.
Thank you, my Lord. My Lord, Honorable Mrs. Scholar, the chairman of this session. I also want to acknowledge all the justices here present. I also want to acknowledge the presence of the learned senior advocate, Mr. Sasha Tituloye, SAN. I also want to appreciate the presence of our magistrates and our distinguished colleagues. Well, I received a text message from Dr. Olatunbura at about 10:30 this morning that I'll be representing him at this forum. But I will try to do justice to the topic since it is a familiar terrain. Thank you, sirs. Well, I will start from where my Lord hinted earlier that since the advent of democracy in 1999, we have gone through a series of elections. And I think the first notable one we did was the 2003 election. And I remember that during that time, I went to vote in my ward, in my unit. And along the line, thugs came and carted away the ballot box. And right there in our presence, the thugs were printing the ballot papers, and all of us were helpless. There was nothing we could do. And unfortunately, our party lost the election. And that was what was rampant in 2003 election. The politicians patronized the thugs. And when they give them money, they give them guns, they go around the polling units, shoot into the air, carry the ballot paper, and then go somewhere to print, and then return, and then they collate, and the winner emerge. And what happened? People felt this cannot continue. Because as at that time, Mimiko went to court, Oshiomhole went to court, Aregbesola went to court. They were in court for about 2 years to prove all of these electoral practices that happened. And the outcome of the tribunal, we all know, those governors were displaced, and the court brought in the new governors that were validly elected. But the reform came, and then the legislature felt we need to put a stop to the issue of ballot stuffing and ballot snatching. And then they changed the Electoral Act and said that where there are instances of such occurrences, the presiding officer should cancel the election of the unit. And that's a reform. Because I remember that the subsequent election that came, and when we went to vote, after people casted their votes, the ballot paper was there, the ballot box was there, and people were wondering, where are the thugs? They are not here. Everybody was looking at the ballot box. It was intact until the election was counted and results were announced. Why? Because a reform came and then removed the issue of thugging. Because politicians now know that when you patronize thugs, they will cancel the election. One copper, who is the presiding officer, will just cancel the election, and that will be all. So politicians stopped patronizing thugs and then devised another. But that was a reform that ended that era. And then when the reform came, they also looked at it that
when they thumbprint, it is also an indication of overvoting, because apparently the people that are at the polling unit to vote will not be up to the votes that were returned, because the thug was somewhere doing, in fact, they can thumbprint an entire ballot booklet. And then when you look at the voters register, you see that just few people's names were ticked on the voters register. So the Electoral Act was further reformed, and then they introduced smart card reader to also aid the issue of accreditation, so that when you accredit manually, there's also an electronic means of accreditation. That was another reform. And then that reform actually had a setback, because if you remember the case of Wike, Wike and Peter Side. Peter Side won at the tribunal, raising the issue of non-compliance, that smart card reader was not used in majority of the polling units. He won at the Court of Appeal. Wike appealed to the Supreme Court. At the Supreme Court made a pronouncement that turned around the case and stated that smart card reader was not expressly provided in the Electoral Act, and as such, that issue of non-compliance is not be proved. And then Wike emerged as the governor. Now, another reform came because we saw that there was a lacuna in the Electoral Act which did not make provision for the use of smart card reader. And then the act was amended, and then they introduced electronic means of accreditation. And that's why we still have the use of BVAS to today. And you will also recall, sir, that that reform also suffered some issues, because there are many villages that did not have network. They also encountered the issue of electricity and so on and so forth. And then the alternative to the use of smart card reader was, if you cannot use smart card reader, resort to manual accreditation. And that took us back to the era of rigging through manual voting. And then the reform came further, that okay, when we now started the use of BVAS, there was a reform that said, where a polling unit, BVAS could not be used for a particular reason, election in that polling unit should be postponed, maybe to the following day, to enable them use BVAS machine. Because currently, our Electoral Act forbids manual accreditation. Accreditation must be done by the use of BVAS. If BVAS cannot be used on the day of election for any particular reason, the Electoral Act says you postpone the election to the following day, in order for BVAS to have a stand in our law. That actually came to be. But that also suffered another challenge, because the Electoral Act tried to prioritize strictly the use of BVAS machine. But when you look at the case of Oyetola and the case of Adeleke and Oyetola, you see that the Supreme Court still made recourse to the use of voters register. That even where you use BVAS, you must still use voters register. I remember there was a case I did in 2023, and then we raised an issue that even though BVAS was used, but the voters register was not ticked at all. At least we saw about 5 polling units wherein the voters register was not ticked at all. And unfortunately for INEC, they called the witness. And what we simply did was we put those documents that were earlier dumped, because we didn't see any witness to speak to it. But unfortunately, INEC called the witness, so we just gave INEC witness the document. Look at that voters register and show this court where there's any tick on it. The woman was shocked. She didn't even know we had those documents at her disposal. And she admitted at that point that by now there was no tick. She was able to identify 5 polling units where the voters register was not ticked at all. And in our written address, we dwelled on that. And the tribunal agreed with us that the failure to use that voters register also validated those the election in those polling units, and those polling units were indeed cancelled. So our point is, because in the case of Oyetola, they tried to prioritize the use of beavers only, or the relevance of beavers for election process. But the court also made the pronouncement that accreditation is incomplete without the use of the voters register, so that we can checkmate the two, because politicians are smart, and in every election year, they come out with different strategy. So the issue of beavers is good for the system, but it is also good that we marry it with the use of the voters register. Because the voters register, accreditation on it must tally with that of the beavers, and also must tally with that of the accreditation quoted on the results sheet. So if these accreditations are in tandem, then the election in that unit is proper. And also, we also agree that that was the time they reformed the election process, that accreditation and voting must go side by side. Because in those days, they were about to accreditation and count people. Then later, voting will start. But they reformed the process and said that the two must go together. So then also, Adeleke's case also has raised an issue that is also affecting most of the petitions filed in court, because the Supreme Court made a specific pronouncement that to prove overvoting, you don't just bring the extract of the beaver. Because what most litigants do is to file an application to INEC, please give us the extract, the printout from the beaver's machine. And if you follow the case of Adeleke and Oyetola, you discover that the beavers were not synchronized at some point. So they were tendering of various beavers reports. And the court now said, to establish overvoting, bring the actual beavers machine. But that is also a challenge, because when you are challenging about 1,000 or 2,000 polling units, and you are then asked to produce each of those beavers machines, and then you don't just produce it alone, you must demonstrate it, open it, and let the court see the content of the beavers machine. We did a petition in Edo State that just concluded, and one of the setbacks we had in that petition was that we brought about 149 beavers machines to court, but none of them, we didn't call any of the INEC officers to come and open them and tell the court said those beavers, because what we did was we have the extract of the beavers. But we're trying to tell the court that this is the machine, but look at the extract. The extract is the content. They said no, even the screenshots, we got the screenshots of the figure on the beavers machine. And then we tendered duly certified by INEC. But the court still said no, we are not going to rely on the screenshots. They even tagged it as documentary hearsay. That what they want is the machine itself. Show us what is on it. But you know that is insidious work to be done. So the reforms are there. Then also, there's a point in our electoral act wherein politicians rely on unlawful exclusion. Once they lose the election, they will wait. And after the conduct of the election, they will go to INEC and get some documents to say, particularly those mushroom political parties, they will go to court and say, our party was omitted from the ballot paper. And the politicians feed very seriously. They empower themselves through that process, because once they go to court, they know the consequence of that action. They know that what the court can do is to invalidate the election after. So they find it, not because they want to pursue the case, but because they want the winner of the election to come and give them money. That was rampant. And you see people going to court. I remember there was a year we wanted to find one. They waited until the last day because they didn't get people to come out, but they wanted to raise that issue so that they can get patronage from the government. And then another reform came. I said, let's put a stop to this nonsense. And then the Electoral Act was amended. And then the issue of unlawful exclusion was removed as a ground to challenge an election petition. It is now a pre-election matter. So they are going to come to challenge an election on the ground of unlawful exclusion. They are just wasting your time. That's a reform to also checkmate the activities of our politicians. Also, if you remember, after Mimiko won the first election, the second time election of Governor Mimiko, there was something they introduced, Edibu, SAB. Politicians saw that they could not use stocks again. What can we do? So they began to induce voters through Edibu, SAB, giving them money and all of that, ISP that. And we are still grappling with that problem till tomorrow. Because that, and to prove that ground, it falls under the ground of corrupt practices. And unfortunately, the electoral, the way it is couched, particularly, there's a particular ground that says that, one, the election was invalid by reason of corrupt practices or non-compliance with the electoral act. Now, if you're a petitioner and you go to court and you know these two, if you state it the way it is quoted in the electoral, you will run into problems. Because there are electoral jurisprudence that says you don't log a ground of non-compliance with ground of corrupt practices. Because corrupt practices has a criminal issue with it. So you must, the burden of proof is proof beyond reasonable doubt. But that of non-compliance is on the programs of evidence. So you cannot lump the two grounds together. So how do you prove inducement if you cannot lump non-compliance with corrupt practice? Because there is an overlap, a thin overlap between facts of corrupt practices and facts of non-compliance. So these are some of the challenges that we have in our, and so many petitions have suffered a setback on the couching of the ground of the petition. Because once your ground is not couched the way it should be couched, you run into the problem and the petition will be thrown out. Then we'll see that also this takes me to another issue that we face in election jurisprudence. The act itself, my own personal opinion anyways, I believe the act itself is against the petition because we have a lot to prove. I remember the last case we did in Edo, we did our best. About 14 senior advocates were in our team with several of us who are young lawyers or lawyers from the outer town. We were sitting down with they would project the pleadings, and all of us, we'll be reading it line by line to be sure that we follow strictly the electoral, that all the work we did, the court just threw everything in. So the act itself, I believe it is skewed against the petition. And then I made recourse to the issue of the OSCP. Now, one of the things the reform has done, if we look at section 127 and section 121 of the Electoral Act, they have now introduced punishments for inducement in election matters. I don't know, maybe time will not permit me, I will have read this section. Section 121 and 127 and 121. If you go back, you can check it. You see that the reform brought punishments for inducement in the election. But the challenge is how many people has been prosecuted for inducement in election matters. I remember I think some elections that passed, EFCC were deployed to polling units to check whether people were doing vote buying. And some people were arrested, actually. But the point is how many of them have been prosecuted for election inducement. That is another thing. The law is there, but that is another thing. And also, personally, I have an issue with the Electoral Act. Because the burden of proof, like I said earlier, the burden of proof of the petitioner is enormous. Now, the Electoral Act says the petitioner must file his case within 21 days after declaration of election. Now, that condition relates to election petition for House of Assembly, which is like a minor constituency involving maybe just 2 local governments. No, 1 local government. Some 1, some 2, some half. Now, the same condition of 21 days applies to election for House of Rep. House of Rep is about 3 local governments, if I'm correct. About some 2, some 3. Now, the same 21 days apply to senatorial election. Now, senatorial election, by calculation, comprises of about 6 local governments. Oga said in Kano, we have about 14 local governments constituting a senatorial constituency. And then we leave that one. And then the same 21 days also apply for governorship election. You know, those states, we have about 18 local governments. In some states, they have about close to 44 local governments. And the same day apply to each of these various of elections. And then you will now leave governorship and then you go to presidential election. They say 21 days for petitioner to file election petition in the entire country. You can see that it is an impossibility. The act itself has killed the case of the because there's no how you can prove with the way the court pronouncements are going. The petitioner cannot succeed in any of these elections. Because I remember that Mimiko's case, they were in court for about 2 years plus. And with those 2 years plus of litigation, they did not come up to 100 witnesses. So if you are going to challenge the election of an entire state, the problem is you have just 180 days to prove your case. Because they want to streamline the time. But the time that has been streamlined, they did not put into consideration the size of the constituencies in which petitioners were emerged to challenge election petitions. It's the same burden of proof, generally for all elections. So my personal view, I believe that the Electoral Act is actually against the petition. That's another point. Then I want to also, because that will now lead us to the issue of how do you prove your election through documents. By the time you are challenging a governorship election, you go to INEC, you apply for citizenship. Because of the burden of proof, based on your allegation of overvoting, for instance, you have to go and get certified copies of all the voters register used for the election. Or even if you are challenging, maybe let's say 1,000 polling units, you get the voters register of 1,000 polling units, you get the results of 1,000 polling units from ECAT, ECAB, ECAT, and the likes. And then you get that. The court has said you produce beavers for each of those polling. All of these are, and then they come to court with bags of documents. And then they say they give you, when you do pre-trial stage court, at first, the first 3 months is for filing response, you file reply, you file response, you do pre-hearing. Before you know what's happening, you are going into 3 months of the petition. And then the judges will now begin to look at the volume of work. And then the time they have to evaluate those documents, the calling of witnesses, and then the time they have to sit down to look at all these documents and then deliver a judgment within the space of 180 days. Sometimes, I remember the time we did the election in the Dakwa building, the time was so short, we were sitting till late in the night. Because the judgment, the court were now on us. You must call your witnesses. Because the documents are many. And they need to evaluate these documents, evaluate witnesses that you call to prove your case. And at the end of the day, when you put your documents down, the electoral actually says you tender the documents, you need a witness to tender them, and that will be all. The other party may refuse to call witness, so who will speak to the documents? At the end of the day, they will come up with a judicial decision that those documents were dumped on the tribunal. Then that issue also made them call for a reform. They now introduced Section 137. Okay, my time is running. Okay, I'll round off now. So they now brought in Section 137 to cure the issue of calling of witnesses. The Section 137, if we read it critically, you discover that the section itself has its own lacuna in itself. And that section has not really cured the issue of tendering of documents and for the courts to review, because the judicial pronouncements across board is that despite the fact that you have your documents there, and despite the section 137 that says if there are material, certified documents, there are material things there that shows manifest non-compliance, that you don't need to follow them. The courts have still maintained that you need to call evidence to substantiate what is on the document. So that is another. So Section 137 has not cured the problem it was brought in to solve. I'm rounding off now. Then, lastly, sir, I want to talk about the conspiracy of silence. Now, the Dapo Abiodun's case, the case was strictly against INEC. My boss, Dr. Remi Olatubora, we were representing INEC. And at a point he had to leave, so I stepped in. And then we were having a meeting, myself, Chief Wole Oladipekun, and Chief Tayo Yetibo, and we agreed that INEC will not call any witness. The reason being that the case is strictly against INEC. So if you bring a witness, just one, the petitioner will establish the petition through the witness. So there's a conspiracy of silence. Even in a Edo petition, we suffered the same issue because INEC will not call a witness. And the truth of the matter is that INEC is supposed to be an unbiased umpire in election litigation. But we have discovered that INEC naturally will conspire with the winner. That's why I call it conspiracy of silence. And we are still facing that problem till tomorrow. So that brings me to my final point, that there's a reform I feel should be brought into election litigation. If that reform is brought into election litigation, I believe it will change the scope of our election jurisprudence. And my suggested reform would be that the burden of proof on election cases should shift to INEC. Because INEC is the one that conducted the election. Come and defend the election you have conducted. If our reform can take to that stand, wherein the burden of proof shifts to INEC, I believe that there will be a change in our election jurisprudence. I thank you.
Thank you, Mr. Obido. We have been blessed with your experience over these years. Mr. Obido, speaking in mind of Dr. Olatubora, took us from where I started in 1999, the era where people were stealing ballot boxes. Then we graduated from, we initiated reforms that made that irrelevant. Because if you steal a ballot box, the election in that polling unit to be cancelled. Of course, politicians like malfeasance, they are always a step ahead of the law. It devised means of getting ahead of the electoral law. This did not discourage the legislature and those in charge. They intervened by bringing in beavers. Of course, this also suffers some deficiencies. We are still improving on that. But thank God, the system now is better than it was in the past. I had a great according to him, the greatest problem confronting our electoral system is the burden of proof. Of course, INEC conducts the election. It declares results. Under the Evidence Act, an official act is presumed. Under, I think there is section, I can't remember the section 149 or something like that. An official act is presumed to be regular. An INEC conducted the election and released the result, which makes it an official act. Now, the onus is on the person challenging the result to show that they have not done it very well and that they have not followed the law. It is not always very easy. Like the governorship election. Election will have taken place in maybe more than 2,000 polling units. For someone to prove irregularity in those polling stations may be very, very difficult. So it's now suggesting, not to talk of the presidential election, which is all over the country, it's now suggesting that it would be good for all of us if INEC is made to defend what he has done. Of course, they will now bring documents to show that the result they declare is what the people voted all about. Yes, we have heard from Olumide Ogido Esquire, who now listen to the perspective of Honorable Edema, who is a practicing politician and a man of these words. Mr. Honorable Edema, you can speak to us.
Thank you so much, Mr. Chairman. I refer to my lords, my fellow colleagues, distinguished ladies and gentlemen. I'm speaking here because apart from being a lawyer, I've been litigant in several election matters, both pre-election and post-election matters. So I can say I've been a victim, sometimes also the winner of certain cases in election matters. So I have felt both the good, the bad, and the ugly side of it. At least on the strength of that, I will be able to say, oh, maybe if we had done it differently like this or done like this, or what could I have done better? Because as a person, I don't like to shift blames. I like to take responsibilities for my actions or inactions most times. But before I go, the lead discussion has said a lot of things. So maybe I'll first of all come with my recommendations so that I don't lose track of them. One, in gubernatorial elections, I believe that the Court of Appeal should be the court of first instance. So the appeal goes from the Court of Appeal to the Supreme Court. And this is in tandem with the two layers of adjudication in election matters or most tribunal matters. You will notice that apart from gubernatorial elections, all the other post-election activities or actions have two layers, from the election petition tribunal to the appeal, and that's the end for assembly, for reps, for senate, and for presidency too. It's from the Court of Appeal directly to the Supreme Court. How come it's only in gubernatorial matters that we start from tribunal, you go to the Court of Appeal, and then to the Supreme Court? We all know the history in Wamako case, how the Supreme Court became interested in wanting to know the outcome of a gubernatorial election. Yes, people will argue that it allows for uniformity of opinions of decisions in election matters. If the Supreme Court is so interested in the outcome of a gubernatorial election, why do we have to subject individuals and to those tedious situations of starting 180 days in tribunal, 60 days in Court of Appeal, another 60 days which no other positions offer. So if they are interested, let us start with court of appeal, like the presidential election, so that the court of first instance for gubernatorial election will not be the court of appeal, since almost every state has a division of the court of appeal. So that's one of my suggestions, which I think the rapporteurs will note, since the constitutional review is still going on and the Electoral Act. 2, the lead discussion also talked about time allowed for filing petitions. I also believe that the time is too short, 21 days is too short. So we can still be back to the 30 days rule and now narrow the issue affecting elections to only one thing: non-compliance. Non-compliance with the electoral. So that on the day of election, that will be the sole issue that the tribunal will be treating. Not even corruption cases, because you will hardly be able to determine the corruption issues, because the standard of proof is so high. So I will still want to recommend the usual 30 days for election petition to be filed. Then the other issue is that the issue of eligibility takes bold stand of the court in election matters. Thank God a lot of these are being banished to the pre-election issues. I mean the issue of eligibility. And the issue of eligibility I can categorize into 2. 1, the one under section 66 about whether somebody has fulfilled all those conditions under which you can say that is qualified to contest that election. Then we can talk about the other sessions as it applies as well. In that wise, if somebody is in, for instance, is not a citizen of Nigeria, or has filed a fake or counterfeit result to INEC in time past, or that person has been a lunatic, or has been convicted of crime bordering on dishonesty in the last 10 days, all these ones can come as pre-election matters only. And if they are going to be for pre-election matters only, any constituent or a voter should be allowed to approach the court to enforce that. Because by the time you are now saying that only persons who have participated in the primaries of our election, the law has somehow shut the door against other persons who are not politicians, who are not members of the political party. And when this man wins, he's going to rule or represent them one way or the other. The 2010 Electoral Act allowed any person who has reasonable belief that whatever is published concerning a candidate of a party can approach court. But suddenly in 2022, this was removed. Even when under section 29(4), you said somebody can approach INEC, pay the prescribed amount of money, and yet get documents. But in the next subsection, which is 5, you said a person who has participated in the primary of a party. What is the essence of the document that somebody has paid so much amount of money to collect from INEC and certify? What will be the purport? When he cannot approach a court to say, I know as a fact that this person who is aspiring, who has been fitted by a political party A, has been jailed before, or has filed fake results before, or he is a lunatic and I have record that he was in Yaba and he has not gotten over it. What is the remedy available? So I will wish, under my recommendation, that that session should be modified, and let's go back to the old session in the 2010 Electoral Act that allow any person who reasonably believe that that person is not eligible to be able to approach court under a local standard issue. The other leg of that pre-election matter will now be for persons who are members of their political party. Oh, our party has not complied with its own constitution, or the Electoral Act, or the Constitution of the Federal Republic of Nigeria as amended in the selection of our candidate. That will be a second leg, which is also still supposed to be a pre-election matter. But to be saying only person who are participating in the primary elections that can approach the court under a pre-election matter will be unjust will be unfair, and does not represent the ability of Nigerians to be able to participate in the electoral process. So those are my recommendations, but how did we get here? I want to appreciate the organizers of this workshop, because I look at the main theme itself. The main theme says Nigeria, quest for utilitarian judiciary and roles for stakeholders, which I have rechristened to say the roles of stakeholders in the pursuit of a judiciary that produces the greatest happiness for the greatest number of the people in Nigeria. The chairman permits me to so request, because if you talk about utilitarian, that means everybody will leave the court and come back happy, or majority. That's the principle in our jurisprudence of the utilitarianism. So if we are therefore saying that people should go to court, come back and be happy, then people should know that the court has actually done substantial justice, not technical justice. Like I said, I've had cause to visit the court on a number of times on pre-election matter and post-election matter. In 2015, for instance, I was at the Election Petition Tribunal in the House of Assembly seat here, where it was obvious that INEC itself said the election they announced was inconclusive, but that the election was announced under duress. The resident electoral commissioner at that time came to testify in my favor. The returning officer who wrote the result and who announced, who also wrote a rejoinder that he announced the result under duress, also came to testify, and a host of INEC officials. When the document was going to be written, they said all my arguments, they were nebulous, they were vague, and therefore did not reflect what they were saying. We went to the Court of Appeal. The Court of Appeal said that we should go back. Thank God my lawyer then was there, the senior advocate of Nigeria now, Chastity Loyi. We came back to the tribunal under a different panel. Eventually, when they were going to write the report, they said it was still nebulous. And by the time they were going to look at all those evidence, they said we go to no issues, because they were not predicated upon any of the so-called apartments which they had declared to be nebulous and vague. Is that not technical justice? Will I be happy as a litigant in that kind of circumstance? Even in my recent case at the Federal High Court, when I went to challenge the eligibility of a candidate on the ground that it offends against Section 83 of the Electoral Act 2022. It is a known fact that Section 25 of the 8 of the Constitution of the Federal Republic of Nigeria, as amended, says that no court shall give interlocutory order that will go to the root of a pre-election matter. You should assemble everything and give your final judgment at the end of it all. But lo and behold, the judge said I should go and amend my processes because it does not reflect certain areas that she does not believe in. And I said, why don't you wait and give your final judgment and this interlocutory for seconds? We went to the Court of Appeal. The Court of Appeal said because it was interlocutory appeal in a pre-election matter that did not jurisdiction. Citing Section 285(11). And I've looked at the 285(11) and this is where it says once it's a pre-election matter that the Court of Appeal and appellate court will not have jurisdiction, although we are yet to test that. But that was the position of my lords in the Court of Appeal. So if we are therefore talking about making a judiciary that will make the majority of people to be happy, I think we still have a long way to go. But however, the legislature also have a role to play in fashioning for us laws that looks less ambiguous. Less ambiguous is design. He mentioned Section 137 of the Electoral 2022. I've read it over and over again. It talks about when you present the certified copy or original copy of a document that happened on the day of election, that you don't need oral evidence. And if we talk about literary interpretation of
status. Where are we? Did they say that we must begin to invite people to come and talk to a document that should ordinarily be able to speak for itself? So, distinguished ladies and gentlemen, my love, I think that if we are talking about enhancing the electoral process using the judicial or legislative processes, we have to appreciate the fact that substantive justice ought to be done. That's on the part of the judiciary. Then on the part of the legislature, we have said it. For instance, I mentioned this section 29 from section 4 of the 2022. I don't know why they take delight in wanting to shut out any voter, a constituency, for being able to challenge that this person came to want to represent me is an ex-convict or somebody who has found a fake result or somebody who has been jailed somewhere, maybe in the US or in UK. Because if I don't participate in the primaries or the political party that produces that person, I won't have access to vote. So I think the legislature should also look at that and refer to the 2010 edition of the Electoral Act, which gives any person the right to approach court. So, Mr. Chairman, thank you. That is my short story from the perspective of a litigant and a lawyer. Thank you.
Thank you, Honorable Edema. He has told us his experience, first as a practicing politician who has had issues with election practice in the court, either as a counsel or as a litigant. He has told us what to do. But my view is this. We're all talking about what the judiciary should do in the electoral process. One thing that should be emphasized is that in good democracies, judiciary do not have any substantial role to play in electoral process. We talk about this because we have not been able to develop our electoral system. We have not got to that level where we will not need security officers to be at the polling station, where people will not accept money to vote. The truth of the matter is this: if someone can take 5,000 naira to vote, and the vote of that person is equal to my food, then what is the point? What is the purpose of me going all the way to the police station to vote? We must, one, educate the populace to know the value of their vote. If people can sell their vote, then it becomes irrelevant. Voting becomes irrelevant. If someone can stay in his room and write results, going to the polling station becomes irrelevant. What we should do, the legislature should enact laws that will support the electoral system. And the executive, when I talk about the executive, all of us will still get the executive. Because we are Nigerians, and what we wish is what will happen. So until we get to that level, we won't be moving in a circle. I hope in my lifetime we can get to where every election will not end in the court, because that is not the purpose of the court. Now, having listened to the two discussants, we would ask for the perspective of those that have listened to them. Yes, Honorable Apamba, believe I'm right? Oh, Professor, I'm sorry, I thought I your name, Professor. Professor Apamba. Yes, Yemi Adetoyibo. Honorable Titiloye. Then Justice Ade, Justice Dawes. We now have 5. Please, I can't recognize you, sir. What's your name, sir? Oh, Leo Tetubi. I guess to be gender friendly, not got anyone from our fair mates. Okay. Let me start from. Okay, Professor.
Thank you, my lord. I want to commend the discussants. They did justice to the topic, and they demonstrated their players in that field. But my lord, I want to start from where you stopped, and that is the issue of even having our politicians going to courts to contest election results, whether as pre-election or even after the election. Why is it that in some other countries, even very close by here in Ghana and some other countries, even in developed countries, we find out that, okay, I am saying, are you hearing me, sir? Hello? Are you hearing me, sir? Good. I am saying that I will start from where my comment is from where my Lord even stopped. My Lord said, well, the judiciary does not even have anything to do with court on a normal day. And I agree with that. I think if our politicians can be if they can develop to the point that they are willing to accept election results, whether at pre-election level or whatever, we would not need to go to court. In fact, as a matter of fact, when the last speaker or discusser was saying it, he defined utilitarianism to emphasize that it is for the common good. Now, sir, you know that when this election period comes, election tribunal comes, most of the judges are engaged. And so in those courts where they leave their matter, the matters will be left until they return. So, and even now, as we are talking, Court of Appeal, if you get down there, they will give preferences to election matters. Get down to the Supreme Court. It seems as if the politicians have engaged everyone. So, if you have cases that are not related to election matters, you will stay there till the next 20-30 years. But cases that relate to election matters, you just find out that before you open your eyes. So where is the utilitarianism of the justice system that we are talking about? When the politicians themselves are just covering the court. So what I'm suggesting is this: politicians, Nigerian politicians, we can take a gift from Ghana, we can other neighboring countries. Please take a gift from them. If you do not win now, next time go and prepare and come back and you will win.
Thank you, Prof. Look, gentlemen, we don't have the whole day. Be brief and go straight to your point. Yes, Justice Olajuwon.
Thank you very much, Mr. Chairman. I want to align myself with that, what the chairman of this session and what the professor here just said. So, you see, we need to beg politicians to let the courts breathe. If politicians don't come to court, just like the chairman said, we don't have any business. I was in tribunal in Anambra, I was in governorship election tribunal in Plateau. You discover that people who don't even have business to come to court to challenge the election results are coming to court. In Anambra State, they did House of Assembly election. Somebody, I remember that figure very well because it became very controversial later. Scored 436 in an election, came 60th. He came to court, and lawyers ended him saying he should be declared the winner. A lot of things. So, one we will never get our electoral laws right. Because in Nigeria, laws are not made for posterity. We make laws to guard and protect ourselves. Laws in advanced countries, you see laws that made promulgated the past about 300 years ago. They are still operational today. Why was you keep amending the electoral laws? As I'm calling, people are calling for amendment. So long as it is the politicians that are making these laws for us, we will never get it right. Two, I want a situation where these laws will streamline who is qualified to go to court. They must make pinning down a certain percentage if you participate in an election and you score less than 5%. What are you going to challenge? They should streamline it. And be sure if you qualify to be able to go to court, you will be able, you must have scored about 40%, 50% against the person who won the election. If you make it law, it will come to practice. And then the court will have less to deal with. As it is, if you go to tribunal, most of these laws you are talking about, so the man who's got 436, eventually, we dismiss his case. He went to Court of Appeal. Court of Appeal dismissed the case. But out of desperation of politicians, this man took the justices of Court of Appeal, took the justices of tribunal, and put all of us together and petition us to end this. Out of desperation of politicians. So we need to beg our politicians, educate them, let them be less desperate. If you don't win the election, now you win it in the next time. We should come, and generally Nigerians are bad losers. Anybody who, even if you lose this election woefully, he will come out to tell you they rigged him out. If he wins in the court, oh, judiciary is the best thing that has happened to this world. It's the last hope of the common man. But let him lose in the court. Oh, they are those people they collected. They are worse than the devil. May God help us. That's just a little bit.
My Lord and member of the panel, my intervention will be different from what we have seen so far. And I align with what my Lord has said. We are not getting our democracy well. That is why litigation is so much on electoral matter. The truth of the matter is this. We don't need the time discussants are asking for determination of election petition. You say once 80 days is so not okay, 60 days. If we give 4 years, we will not get justice. Let's face reality. In foreign country, you don't swear in somebody until electoral matter is disposed of with. Somebody will still be in the Senate and he will be facing election petition. And after I have been sworn in the Senate, they will ask him to vacate his seat for another person. It's only in Nigeria we do all this type of thing. I think the basic reform should be election petition in Nigeria must be decided before anybody is sworn into public office in this country. That is the only way out. And it must be streamlined. This level of appellate court is unnecessary. My colleague is recommending the staff of Court of Appeal to Supreme Court for governorship. Initially, it used to be electoral petition to the Court of Appeal. Now, the Supreme Court now was added later. We should return back to the status quo. The way it was done in Nigeria matter. We should start from the High Court, finish at the Court of Appeal. That was how Mimiko or Shomole and all of them got it, and it was nobody said those judgments were wrong. They are still the judgment we are citing the court today. Why moving into the Supreme Court? Now, Supreme Court is taking date of 2029 in 2025. All because they are contested with cases. Look, the court is not made for electoral matters. The court is made for the common masses. And the common masses are being denied justice because we now place electoral matter. Now, very soon, the Anambra election petition will keep on ranging to Supreme Court. It will follow by Ekiti. It will follow by Osun till 2027. The court will continue to adjust civil cases they supposed
decide for the common masses. I think we have to decongest our court. A court, I think, is enough for us to decide, or an appellate court, in finality. We cannot continue like this. We are dancing forward and we are dancing backward. That is the electoral act that is being amended every time election wants to take place in Nigeria. We need to stop it and we need to be focused and develop our democracy. That's my contribution.
Thank you. The last person, Mr. Adeji.
Thank you, my Lord.
It will be the last.
Thank you, my Lord.
Oh, Mr. Otechi, I am Mr. Otechi. The brief, sir.
What I want to say is, the lead discussant mentioned the issue of INEC. I remain here near Beto West Point. INEC as electoral umpire. When you pass the buck to INEC, to be the determinant in proof of election cases, where do we have INEC then? In compliance with the electoral rules, Electoral Act 2022, and when you now contrast that with Electoral 2010, we are all saying here now that anybody can complain about eligibility of candidates and elections under 2010 Act. The Electoral Act 2022 ordinary is an improvement, not anybody, because we can have people who are hired, who are busybodies, to render useless a genuine candidate and enter this aspiration. Then the proof of INEC that INEC must prove everything in Ogun State election. Takwabiodun and Adebutu, not Adebutu, the votes were equal, just like in Kaduna State. But the point is this: how do you prove in every polling booth, just like the presidential election, then INEC, even though those states here, will not want to call witnesses? Again, all of us are now pushing it to them that a petitioner and a respondent does not need to prove who won the election. Where in the world does INEC have to prove? Whether they call witness or not, it is who alleges must prove. Then the cause are there. Justice Adume in the Plateau election, dabbling to the internal affairs of political parties, what brought in Ireland and other senators, that the PDP had this and that. In Kano State, one of our justices here determined the Kano election. Abba Yusuf and Nasiru Gawuna, the Supreme Court set it aside. Again, all along, if Wike did not have the privilege, if it was only limited to the Lord Kaduna and the God of Peace, Wike would have been governor today. So if Peter Sai won at the Kaduna and at the Court of Appeal, Wike won at the Supreme Court. Then what happened to David Leon? Eligibility issue. That today Jeremy, his deputy, running mate, did not have a certificate or the forgery of results. We didn't address that there. They want of election violence. In Anambra now, page 4 of the Nation on Sunday, we had that, stash of Naira notes, back in wheelbarrows. People arrested with it. In Accra here, at the government there, during the Aida and Agola election, all of them, nobody had been prosecuted. We are out here talking about it. I was at the election law reform conference in Lagos in 2013. We are for election, I'm sorry, I'm running on, sir. Let us compare this to papers and let us submit to INEC. For proper determination, we are lawyers, but we are talking every time. The court determine who becomes this and that now. Let us compare them to papers so that at the end of the day, there will be a joint position. It's not then we are talking about impeachment. People go, the election matters 14 days. Nobody's addressing at the federal court. How do you put this together? I participated in 2 tribunals in the Mimiko elections.
Thank you, Mr. Thank you. Please. Otechi, do you have anything to tell us or we run off? Okay, it's not a run now. Okay. Since someone has come out to build women, let's recognize that.
Good afternoon. Thank you very much, sir. So I don't really know much. I'm not very knowledgeable in the area of election petition. But from the little I know, I've seen where an election petition failed because they missed out the grounds for the petition in their processes. So now, if in our laws, in other processes like writ of summons and other ways of commencing an action, the rules of court, they give these litigants and their counsels the chance to bring an amendment if they make an omission in their processes. I want to understand why in an election petition, because from what I got to find out, I stand to be corrected, an election petition, once filed, cannot be amended. Yes. So I want to know why any other process is subject to amendment, but once an election petition is filed and there is an omission in it, is not subject to amendment, and whereby you cannot amend such a thing, any omission or whatever mistake is made in it can cause the election petition to fail. That's my question.
Yes, Mr. Oluwodolu Midogido wants to react to two of the things stated by those who spoke. Yes, Mr. Ogido.
Thank you, my Lord. Quickly before I react to what my Lord Honorable Justice Colonel Dancy and Professor Akpama said, I just want to quickly mention or react to what my sister just said. Well, election petition, like you know, is sui generis. It has its own procedure, which is different from the natural and the normal proceedings we have in court. So, amendment, it's not that amendment is not allowed. You can amend your petition, but your amendment was formed within the 21 days. Once the 21 days time lapses, you cannot amend your process. That is what it is. Now, to come to what my Lord said and Prof. Well, I agree, sir, that litigants don't need to go to court, particularly when it is obvious that you don't have a business in the court. But, sir, I would like to say that, one, they do it for two things. I did a pre-election in 2023 for Emmanuel lost the Senate in Ibadan. And it was just a day to the time of filing to lapse that he called us to come. And when we were doing the file, he told me that it's not that he wants to win this thing, he wants to show them that what they did to him was bad. And so, and at the end of the day, in between the proceedings, he told me to go and withdraw when they settled their issue. So sometimes politicians go to court to vent their anger, not because they know they want to win, but they just want to go there to make a statement that what you have done to me, I didn't like it. That's on the one side. Then secondly, politicians also go to court for political reasons. Sometimes they want to keep their supporters intact, and then they give them the hope that we are going to reclaim our mandate, and everybody will say yes. So there's that mentality that we are going to reclaim our mandate. So even when the politician himself knows that this is a no-no, but to keep the fold intact, they have to do. So those are political reasons. Then lastly, sir, lawyers now take advantage of election cases. Like what Alex said, that, cases are being adjourned to 2029 at the Supreme Court. Somebody wants to apply to the senior advocate. You will not get dates at the Supreme Court in maybe 2030. So the only option and the fastest way to get cases at the Supreme Court is to file an election petition. Whether the man has, in fact, sir, even after the amendment of the Electoral Act that says unlawful exclusion is no longer a grant, somebody filed an election petition in tribunal on unlawful exclusion, even when you know that it is no longer a grant. So lawyers also capitalize on the market. I've seen election cases that are solely sponsored by the lawyer. The politician is not even interested, but the lawyer took it on because he knows that's the fastest way to get judgment at the Court of Appeal and at the Supreme Court. So these are some of the reasons, sir. I thank my Lord.
Thank you.
Thank you so much. I still humbly still want to disagree that politicians ought not go to court. Because we are saying we should not go to court, what you're asking us to do is self-help. And the self-help approach will not be too palatable. Because we are talking about stakeholders, and roles of stakeholders. In any election matter, The stakeholders I can christen as such. INEC, one stakeholder. Courts, one stakeholder. Political parties and the politicians, another stakeholder. The parliament, especially the National Assembly in Nigeria, a stakeholder. Civil society groups, stakeholder. Then NBA and lawyers, they are also stakeholders. In any case, as a litigant, when I approach you that I have an arguable case in a pre-election matter or post-election matter, a lawyer should be able to advise his client based on the knowledge of the law that you don't appear to have a case. Because in election petition, you pay so much as cost to be able to prosecute election petition. But I've hardly had a lawyer in election matter who will tell his or her clients that, oh, you don't have an arguable matter, therefore let us not try it. But again, the internal affairs of the parties, even though the court is saying let us go back to internal affairs now, according to Supreme Court, you still find out that the way political parties manage their internal affairs can never be said to be democratic. And if it's not democratic, somebody will be aggrieved. And what will be the remedy available to such aggrieved person? Other than to go to court. But like I said earlier, let us narrow down these issues, these grievances to one pre-election matter and limit post-election matter to only election day issue. That election, does it comply substantially with the Electoral Act of the Constitution? We cannot be talking about the internal affairs of the party on the day of election. But if you have anything against the party by reason of their not adherence to their Constitution or the Electoral Act or the Constitution, you can approach the Federal High Court before the election. But that will reduce the issue to be discussed on post-election day. You will find out that within 150 days, we will discharge all those things before anybody is sworn in. But because we must do so many things, we say it does not comply, corrupt practices, and the dignity is even put there. So you'll be calling people to come from UK to come and say, we have a certificate of somebody who went to Chicago and his name was not there. How many years will it take us to educate on that? Limit the issue of post-election to compliance, only compliance with the Electoral Act on the day of election. That will reduce the volume of job to be done by the court.
Thank you. We thank the MBA that has given us this platform to be here. I believe we have done justice to the topic. My final word will be this. The people get what we can do far better than what we're doing presently. If we collectively decide to do the right thing. If election is free and fair, the road to the court there will not be many people that will approach the court. We have this problem of going to the court because election petition is a huge business presently because our election is not thorough and fair. Of course, if it is not thorough and fair, we expect someone who believes that they have been cheated to go to the court. Until we are able to have a fair system where those people are voted for and those that are announced, we may still have this problem. It is where the legislature and the executive are very much required to do the right thing. I will still submit that they should limit the participation of the judiciary in the electoral process because the judiciary is not made up to do that. Thank you for listening to me.
Thank you very much, my Lord Justice Kolawole. Thank you very much, Chairman of Panel, Chairman of Session, Mr. Benga Ideba. Thank you very much, and of course, Mr. Lu Ude Ubido. Thank you very much. Please, gentlemen, you may please sit. Thank you. Let's put our hands together for them. Thank you. Thank you very much. We move straight to the third and final session, after which we will do lunch. We'll be very quick with the third and final session. And the focus of the third and final session is judiciary as a catalyst for economic development, efficacy of court judgments. And to chair the session, distinguished ladies and gentlemen, I have the privilege to invite my Lord Honorable Justice Sunday Oloro Dawson. Also, distinguished ladies and gentlemen, I wish to invite to the seats for the session my Lord Honorable Justice Professor Alero Akeredolu. Let's put our hands together for my Lord. May I also invite my Lord Honorable Justice Adeshola Ibat. Thank you very much. We will have a chairman of session and an alternate chairman. And my Lord Honorable Justice Sunday Oloro Dawson is the alternate chairman of session. So while we wait for the chairman of session to arrive, we will begin this session with the contributions of the alternate chairman. I therefore wish to respectfully invite to the microphone my Lord Honorable Justice Sunday Oloro Dawson. My Lord, sir.
My Lord, distinguished members of the bar, your worships, I welcome you to this session. Yesterday I was here as a substantive chairman of the session. This afternoon I'm an emergency chairman of this session. But the very good thing is this. The man who is to chair this session is right on his way. So don't be surprised to see the emergency chairman vacating this seat as soon as possible. But before he comes in, I will set the ball rolling. Time is precious. start doing something. But I want to let you know as soon as it comes, I will vacate this seat. They've told me to be a discussant. From an emergency chairman, you may see me becoming a discussant in this session. Once again, the topic before us this afternoon is judiciary and as a catalyst for economic development, efficacy of court judgments. You see, incidentally, we are no longer in the military era where judgments of court are flouted. But incidentally and unfortunately too, we still see these things happen. I gave an incident yesterday of a recent court order made in my court that was flouted. And if I have the time, I would still like to share that experience with all of us. To do justice to this topic is, this afternoon, we have two eminent members of the Ondo State Bench. We have Honorable Justice Professor Alero Akeredolu. He's a learned professor. He's a learned judge. Everything about her is learned. He's an all-round personality who has what it takes to discuss this topic. He's been on the Ondo State Bench for a while. Another discussant for this afternoon session is my Lord, Honorable Justice Adeshola Ipat. My Lord started as a magistrate in Lagos, a notable one for that matter, and she's been on the Ondo State Bench for quite some time now. They are both erudite judges. They both have what it takes to discuss this topic. I want each and every one of us to listen very well and see and be ready to contribute. We are talking about judiciary. The whole essence of this law week centers on the judiciary. So you can see the bar trying to see how we can synergize and work together and make the judiciary of Ondo State look better. So without wasting much of our time, I would like to hand over the microphone to my learned brother by my right side. So let's hear from the professor. And as soon as she finishes, if I feel here, I still have the privilege of continuing as chairman. Maybe I will stand and I will call on the second discussant to take over for her. Learned professor, it's now, the ball is now in your court. Thank you so much.
Thank you very much, my Lord. Good afternoon, everyone. Good afternoon, my lords. And seniors in the legal profession and every other person.
Yes.
First, let me say thank you to the bar for inviting me to speak and share my thoughts on this topic. The theme is Nigeria, quest for utilitarian judiciary and roles for stakeholders. But we have been asked to speak on the judiciary as a catalyst for economic development, efficacy of court judgments. So the topic, looking at it in the first instance, I felt maybe the person, they gave Professor Abampa or somebody on the academia to couch the topic because it's quite wide. You could do a thesis on this even, taking it from different perspectives, and I guess that's why we have different people to speak. But just so we're on the same page, these are my own thoughts, and let me say, taking some of the key words there to say what do I mean or what do I think the organizers want us to talk about. Ordinarily, when we say judiciary, I'm guessing most people focus on the judges. But in our context, if we are talking about a pursuit, which is like a journey, pursuit for utilitarian judiciary, then that includes more than just the judges. It means we are talking about the system. We want to talk about the system. So it covers all of us in this hall, and those, some of us are not even here. Covers the judges, covers the magistrates, covers the administration. That's the supporting staff. And all of us at the minimum.
And then we're talking about being a catalyst. That means you want to introduce something that can make your outcome easier or faster. And I asked myself, is there something the judiciary, remember now when I say judiciary, I'm talking about all of us, not just the judges. Is there something the judiciary can do or that we're doing that can make economic development faster? And so I said to myself, when you say economic development, what are you talking about? And I said, it's just a fancy way of saying money matters. Economic development is about how much money is flowing to and through your pocket. If you think of economic development, national or state, that would be too far. I think we have to think of this economic development in terms of ourselves, and that's part of the emphasis I'll be making. So is it a role for the judiciary that we have at the back of our mind economic development when we are performing our judicial duties? When the court staff are playing their role, should they be mindful that this has economic implications? So let me start with a story. It's a real life story mixed with fiction so that you can get to the bottom of it. About 15 years ago, while I was in practice, I helped one of my in-laws from my father's side to buy, they are in diaspora, they live in England. They wanted to buy property in Ibadan, prime property, prime area. And I assisted in buying the property. By the time they started work, they actually wanted to build a school and a guest house. By the time they started work, somebody came to the site and harassed them, arrested the workers and all. So we had to first go to the police station to deal with that. And then, of course, subsequently, the police said, go to court. So we had to institute an action in court. That action was instituted in 2009. Ladies and gentlemen, your guess, just take a wild guess when that trial completed. Judgment was delivered May 2025. I kid you not, this is real. May 2025. Remember I told you what that property was going to be used for. And there was an injunction. So nothing was happening on that land in the past 14 years. Are there economic implications? Of course. If that school had proceeded, during the stage of construction, some people, money would have flowed into their pockets. When the school was built, if eventually was built, some people would have been employed. The guest house, what today we all call Airbnb, which is common now, but then it was just like a starting. They would have had people employed there. The money in circulation would have improved, no doubt. But then, 14 years later, we just got judgment. And so sometime last year, a friend of his, also in the UK, wanted to come and invest, bring funds. Please, like my people will say, Ejo, advice will never happen. Know the person is really your friend, asking you for advice now. That I want to bring money to Nigeria to come and buy land to do this. What's going to be your answer? So that cycle will go on and on because a friend will tell a friend to tell another friend. And what happens is that money that could have come into the nation, maybe from 5 different sources at least, and could have improved the lives of people here in Nigeria was just cut short because of the interaction with the justice system. So we're actually talking about money. We're not really talking about say, oh, economics of Nigeria, GDP of Nigeria. I don't even know those ones because maths is not my vocabulary. But real life people and real life cases that things end up affecting because of their interaction with the justice system. So that leads me to 2 points which I want to say or emphasize here today. The first is to say that fairness and timely protection of property rights, fairness and timely protection of property rights is a catalyst, is one of the ways, one of the fundamental ways that the judiciary, and when I say judiciary, remember I'm talking about you and I, not just us on this podium as judges, one of the fundamental ways that economies are impacted. I go back to the story of my in-laws. Let us assume that they took a loan to buy that property and for renovation. 14 years later, if they had no other source of income to pay off that loan, they would have gone bankrupt. That's the truth. They would not have been able to pay the debt, they would have gone bankrupt. What am I saying? Utilitarian theory of justice will tell us, just like my brother Honorable Edema said, the greatest good for the greatest majority. But by coming in contact with the justice system, what was their expectation? Or what was their outcome? Now, let me speak to how the lawyers in the system also affect the economies or the economic development. A lawyer who files frivolous applications or asks for unnecessary adjournments and as a result elongates the life of a case, that lawyer has to take responsibility and know that you are affecting, it may be your sister or your cousin, who could have been employed by those businesses. But because you are dragging cases, you think you are looking out just for yourself, you are ending up reducing the money in circulation and you are reducing the money that is flowing to other people in the system. So the judiciary staff also, who is negligent, thinks he's just doing himself, or think he's just servicing himself or looking out for himself. But the truth is that when you don't have timely, fair judgments proceeding out of the court system, it is money cut short in the system. And at the end of the day, business owners need to have confidence that they can securely own and transfer property. And then if any dispute arises, that within the shortest possible time, they will have it disposed in a fair manner, a predictable manner, no matter who is involved. Because time is money. This peradventure is what led to specialized courts, like the Lagos Rivers and the FCT, where you have courts that are for commercial transactions, realizing that, look, these things are important. The court system must be able to deliver effective justice in a timely manner, particularly in business transactions, because of the impact that they have on you and I. Like I said earlier, Leave Nigeria is quite large, but on you and I, if we're talking about justice system in Ondo State, investment in Ondo State, it's about you and I. It's not the person in Abuja that will be impacted, even though indirectly, yes. But primarily, those of us that are here that will be the first beneficiaries or losers when money is short-changed or cut short. So let me give 2 other examples. A person comes to Ondo State and buys hectares of land for the purpose of investing in cocoa or any other agric business, palm oil or something. He has planted the farm. He has expended money. 2 years later, community arises and says this was actually community land. And one of the areas where there's a lot of delay in disputes is land transactions. So this land that has been cultivated 2 years later, expecting that returns will come in maybe like 5 years or thereabout, is now trapped in litigation. Many times they will come ask for injunction, maintenance of status quo, so that nothing goes on in the interim, without imagining that this is money. This is money in the system that needs to continue to flow. So what should the court system, how should they handle it? What should be the consciousness of all of us? In such cases, we have to be aware that money is involved. We should give it our best shot to ensure that we process it out of the system as fast as possible, as fairly as possible, and as predictable a manner as possible. And it's not just about the judge. It's about the lawyers, and it's about the staff. Let me talk about law as a business and how this plays out also. Because we are looking at economic development. I could look at efficacy of judgment, but ultimately it is the impact we are talking about. What's the impact? And I want us to at least be able to look at it from the monetary things, monetary aspects. The legal profession offers legal services. It's a professional business. The easier, when litigants know that when they approach the court system, it is not a forever thing, they will keep coming. But if they believe that the court system cannot help, or that the court system is going to keep them forever, they will search for alternatives. There was a time when I was sitting in Ondo, there was a protest by lawyers at that time. I'm not sure if it covered the entire state, but I know that it happened in Ondo. When they were protesting that parties should not use affidavits to transfer land. Why? Parties began to look for an alternative because they felt that the justice system was not working, or it would take too long for them to process things through the appropriate channels in the justice system. And when the lawyers had to protest, they were only protecting their pockets. That's the truth. There was an alarming drop in revenue, ADR. That alarming drop in revenue prompted the lawyers to say, what can we do? We need to involve the judges. We need to involve the courts. We need to involve everybody to say, oh, no, affidavits in transfer of lands must stop. So everybody needs to protect their pocket. Everybody needs to protect the money that is flowing in and out. And the justice system has a great role to play in that respect. If the clients eventually believe that lawyers cannot get them justice, they will go elsewhere. And that will not figure well or augur well for all of us stakeholders in the industry. So we all need to be conscious of this. Yes, there are clients. Yes, there are peradventure people you just know that came up, maybe they were referred. I think at the back of all of our minds, we need to understand that these are real-life people with real-life economic situations, even though they have brought the matter, just like maybe it's a land dispute or it's a contract dispute, realize that it is, at the end of the day, all about money. And money needs to keep circulating. If the lawyers, the money you have will affect what type of school you send your child to. The money you have or do not have, as a legal practitioner, will determine whether you can buy a car or whether you have to stick to Okada for long. So it is our own economic development now we're talking about, not economic development of Nigeria. And then the second point. So my first point, if I can recap, is to say that there needs to be prompt fair protection of property rights, because these things affect or have to do with money. My second point is about attracting foreign direct investment. And there are levels to this. Many times when we talk of foreign investment, we are thinking of the multinationals that come to do oil, that come to do bitumen, refinery, like we had in those states last week, that there were partnership agreements signed. Everything has the high scale, medium, and the small. My in-laws in diaspora, yes, theirs was small, but it was also foreign investment. They were going to bring money from outside into Nigeria so that more money can flow among people in Nigeria. What do they look at when they are coming to invest? Or want to make a decision whether or not to invest? Ordinarily, it is the lawyers they ask to do due diligence. What are the factors that the lawyers look into? These are questions, if you are doing due diligence, that you will ask, because even the World Bank admits that a stable judiciary is a benchmark. So a foreign investor, whether small, medium, or large, in making a decision whether to come to Nigeria and invest or not, ask themselves, one, how long does it take to resolve different types of commercial disputes in court? Two, does the legal framework as it is support private dispute resolution? Because many business people have come to the conclusion that, look, the court is a no-go area. When the courts have to intervene, how do they look at things like arbitration process? Is this jurisdiction a place where they still view ADR, still view arbitration with suspicion? And I'm sorry to say that a lot of lawyers till now still look at ADR with suspicion. But if you're going to deal with investments, that has to be included in your contracts. So we can't escape it. We need to embrace it. A third question they will ask is, how easy is it to enforce judgments? And then the monetary consideration. How much does the process cost from beginning to enforcement? What is the likely cost? They will compare this with their investment. So if 30%, if I have a dispute in an investment of 15 years, for example, there's going to be disputes. You can't work for 15 years together and you don't have minor or major differences. So when it arises, how much is it going to cost me to resolve this dispute? If from the calculation, cost risk analysis, they say it's going to cost you 30%, you look at it, is that high? Is that something I can accommodate? And if not, where do I go from here? So that's why we have a lot of the government talking about the ease of doing business. Why? Because the reality is that if whether real or imagined, the perception is that Nigerian judiciary does not deliver timely and cost-effective resolution of disputes. Now I say real or imagined, because sincerely, since I joined the bench, there was a day I tried to look at the docket. I looked at my docket and I did not see cases of 1990 something. I did not see cases of 2000. I saw cases of 2020. And for that 2020, which was an isolated case, I told counsel, I said, see, we are finishing this thing in this legal year, whether you like it or not. Whether I'm going to push you, drag you. I said, because imagine you are the litigant. 5 years later, you haven't gotten justice to even just know which direction you are. I said it's unfair. So no matter what application you are bringing, you want to amend your processes after 2 defense witnesses, my answer is no, you can't. stay of execution, stay of proceedings, pending notice of appeal. It's your right to appeal. Go and come back, you meet me here, but nothing is going to happen. We are going on. Because you have to put yourself on the other side, that everything has cost implications. Everything has money implications. So in Ondo State, I think I can say with all confidence that we are not part of that reality. That's not our reality. I know that we are working and then we actually do resolve disputes timelessly here. So I will give a round of applause for myself, even if you don't want to greet the rest of us. And we are very many here, and I can speak for all of us. Yes. So people are forced to seek alternatives. So a few years ago, we had people talking about industries were moving out of Nigeria. The question is why. They were counting their costs and seeing that it was more profitable for them to both invest, do business, and at the end of the day, even if they have reason to go to court or to employ private dispute resolution, which is ADR, they are sure that their court system supports ADR. Investors want to know if there is change in government, would my contract still be valid? All these are money considerations that they give to it. These things happen in Nigeria over and over again, that when a government changes, the new ones refuse to honor contracts. And when you go to court, you can end up 7 years, 5 years, trying to just get your money. And at the end of the day, when you get it, what is the value? It has depreciated grossly. It has depreciated seriously. So at the end of the day, these are my 2 recommendations. The first one is to improve the efficiency of the judicial system to deliver timely judgments. For me, one of the biggest disgrace to us as Nigerians collectively is that in 2025, we are still doing cases longhand. It's a disgrace to all of us, a national disgrace. So somebody can do a paper tomorrow to say, Alera Akeredolu called Nigeria a disgrace. Bow to God and don't bow to Akeredolu, but it is still the same thing, it's a disgrace. And on this aspect, I wish to call out our senior lawyers in this regard. This is your constituency. Lawyers can donate 50 million, 100 million for Law Week. I'm not saying they should not donate anymore, but I'm just saying when lawyers, particularly those that are going for elections, because I was in MBA for a long time, when they are going for elections, they will do all of these things, donate money here, donate money there. But the system, we are not addressing the system. We are addressing personal gains and personal benefits. And this includes the lawyers in politics and the lawyers that work for politicians. All of you together, I'm calling you out. Do more for the system. What will it cost you to emphasize to the government of the day and say, look, invest in our courts? It's a capital investment, but it is necessary. Because once you do it once, it's just now maintenance. But nobody wants to make that first major capital investment. So we need to do that. Invest in recording systems, e-filings, digital courts, management, and all. And also invest in judicial training to improve the quality of judgments. The second recommendation is to promote and strengthen ADR. Of course, ADR is my breath. God is my breath. ADR is my area. So I cannot but speak about it in terms of recommendation. It is useful. It is useful. ADR gives timely judgments. So I appeal to our judges, I appeal to the lawyers, litigants, take advantage of ADR. It offers cost-effective and timely resolution of disputes. The truth is that when you help your clients resolve their cases timelessly, they will come back to you and they will refer others to you as well. So now my final word is this. I leave you with this scripture that says Numbers 10:29. And I'm speaking for my alternative dispute resolution family. And I say to you all, come down with us, for God has spoken good concerning us, and it shall be well with you. So join ADR trade, it will be well with you.
Thank you very much. That's the erudite professor, Professor Kerry Lulu. Can we give her another round of applause? Without wasting much of our time, I will at this juncture hand over to my learned brother, Honorable Justice Adesola Igbati, to hear her own views in this topic, on this topical issue. Thank you very much.
Thank you very much, Mr. Chairman. Session. Good afternoon, distinguished colleagues and distinguished ladies and gentlemen. I also recognize eminent personalities among us here. Let me express my profound appreciation to the Nigerian Bar Association Akure branch for the invitation extended to me to be a discussant at this session. I also want to thank the lead paper presenter and the lead discussant. She has done beautifully well. I'm not surprised. She is a professor, so please don't judge me by her standard. Yes, I have my own little contribution. Utilitarian ideal. What does this mean? According to proponents like Jeremy Bentham, remember in our days in the university, jurisprudence, Jeremy Bentham, and I think it's John Stuart Mill. What that theory promotes is the greatest good for the greatest number. So when we bring it down to the judiciary, what are we saying? We are only saying a judiciary that is independent, accessible, efficient, impartial. In essence, our judgments as judges must not only be legally right, it must promote social welfare and economic prosperity. What does that mean? In several decisions, let me say I will take it from the national and the subnational level. Let's discuss it from those 2 points. At the national level, there have been several landmark authorities where the Supreme Court and the Court of Appeal have shown that law and economic prosperity are companions that should not be separated. And if I can remember some of the cases, the case of Adetun Oladeji and Nigerian breweries, I think it's a 2007 case, where the court upheld the sanctity of contracts, that agreement that is voluntarily entered into by parties should be binding in commercial transactions. That is promoting consistency and respect for contracts. I also remember the case of BPE and NDIC. You know, I think it talks about, if I can remember now, it has to do with regulatory authorities. The need for them to be consistent and to follow due process. We also have the case of Unwosu and CBN, when the Supreme Court held that notwithstanding that you are regulatory authorities, you have to follow the appropriate procedure before you can effect any, provision of the law. If you breach the procedural aspect and you fail to give the party, the right to express his own side of the case, then also in the case of Darije and the Federal Republic of Nigeria, I'm sure you remember, the Supreme Court upheld the need for accountability among political office holders. All these cases go to show that consistency and predictability, because you cannot hold that position in one case, then in another case with similar facts, you make contrary decisions. This will discourage investors. So that is the position. But as beautiful as these cases are, we need to balance it. There's still something that haunts our judicial system. And what is it? Is this hydra-headed issue of judicial delay, which the late speaker referred to. The mystical hydra, the hairs that were severe, kept growing back. Why? Why do we, at every conference, discuss this issue of judicial delay? I've asked my question, and I think it's what should be of interest to everyone here as participants in the justice sector to ask ourselves, why is judicial delay? Who is responsible? What is responsible? I beg to answer that question by saying, you, the participants, I, the participants, all of us as a whole are responsible for judicial delay. Is it the lawyer that comes with frivolous applications, never ready for his case, always seeking for adjournment? Or is it the judge that is noted for absenteeism, is never ready to deliver judgment as at when due? Or is it the registrar that keeps hiding the case? Judgments have been given, but you cannot get the file to process the certified true copy. Or is it the bailiff that's entrusted with the processes and decided to dump it somewhere without serving the other party? Or is it the Bar Association that fails to punish or to investigate ethical misconduct, who decide to bury it up because it's a colleague of theirs? Or is it the government, the appointing authorities, who fails to provide the necessary funding, who fails to give the independence that judiciary is asking for, that is constitutionally granted? So what are we talking about? We all come, we discuss judicial delay. We are all responsible. And until we are ready to make amends, we cannot make progress. Now, I cannot really do justice to this topic by not talking about the grassroots, because that is where I come from. I hope you all know that I am a judge of the customary court of appeal. You may ask me, how does the customary court of appeal or the customary law adjudication come into this topic? But it is very, very, very relevant. Customs and traditions are ways of life. We breathe it. Yesterday, when Professor Kerr was here, he said about 400 villages are around the Dori. You can now begin to imagine how many local communities are in Ondo State as a whole. Like the lead discussant said, Ondo State, the Sunshine State, you can distinguish from Abuja and Lagos. Ondo State is a civil service state. Majority of the businesses here are medium and small-scale enterprises. And that is why property rights is of great importance. Most of these lands are in the rural areas. We are all products of customary law, either by true inheritance, the marriage, I've said inheritance, chieftaincy, traditional relationship, custody of children under customary law. We are all local people. The question is, why this apathy? Why this apathy against customary law? When we hear about customary law, no, that's not what we are saying here. Have we forgotten that the English common law was not created in vacuum? It came from the local laws, the English customary laws, the unwritten traditions of the English people, of the Anglo-Saxons. Have we forgotten? Is it because the British forced on us the English common law? Then we now consider our old law as inferior to English common law. In fact, some do not even think there's any need to go there at all. But whether we like it or not, that is who we are. In South Africa, in Ghana, in Kenya, one studied their traditional system. Why, let me with due respect say, the High Court is already overburdened. So many cases on their dockets. And meanwhile, we have the customary system in Ondo State. The customary court is there, pleading and begging, bring some of these cases to us. The question is, what is the High Court doing with chieftaincy matters and family land matters, where we have a customary system? Yes, you may say, it is not our fault, this is the Constitution. Yes, that's where I'm going to. What efforts are we making? What efforts are we giving towards reforms? I know that for years, yes, I will round up in 5 minutes. For years, the presidents and chief cadres have been going to the National Assembly just for an amendment of the Constitution, so that customary court of appeal can take all matters relating to customary law. Why do we come to High Court to come and bother you? Why the High Court do the Oyibo cases? Banking, commercial, you can handle all those ones. Leave us with the customary matters. What I'm saying that we are all partners in ensuring economic prosperity. Like Lord Mansfield, in the case of Reyes and Whips, as far back as 1774. He said the commercial world cannot subsist within faithfully adhering to justice. Our own Justice Wales in 2004 brought that home when he said the rule of law is not an abstraction. It is not an abstraction. It is the blood by blood for economic and social order. So, when we are talking about accessibility, because there must be accessibility, everybody must be able to access, justice. We have to go back to the roots. Finally, let me end with the saying of, I think it's is it Whitson? I think I got it. The 28th President of the United States of America, when he said, justice is the first foundation of prosperity. So, in all that we do, let us remember that in the judgments we give, what is of importance is the outcome, how it affects society. Is it promoting economic prosperity, or we are just giving it for the fun of it? As stakeholders, we need to ask ourselves, what role are we playing in bringing about judicial delay? We must all do our respective parts. Thank you very much.
Thank you very much. The erudite Justice, Honorable Justice Adeshola Ipas. I know she's an encyclopedia. You can see how she was churning out cases. To some of us who don't know how to remember cases, we're looking at her mouth. Thank you very much. All of us here will recall that I told you I'm standing here as an emergency chairman. The substantive chairman of this session is around. His Honorable Justice Emmanuel Bamidele Omotosho of the Ekiti State High Court. Madam, you're welcome. Well, like I told you, I said as soon as it comes in, I will vacate the seat of the chairman. And I think I kept to my promise. But the chairman said, since I was here holding forth for him while they were presenting their own views, I should run through a summary. So I will gladly do that. And I want to tell you that the situation on ground has converted me to a discussant. So possibly I will hear my views, and I will go through a summary, just do a summary then, hear my views about this topic and then fully hand over to the chairman of this session. The earlier professor started this discussion by defining terms, judiciary as a catalyst. He said it's a system that covers all of us, judges, magistrates, support staff, lawyers, whether you are a senior advocate or you are a 1-year-old lawyer, it involves all of us. She looks at catalysts as something that speeds up development. Then he asked us a question: what can we all do to make the system better? Then, talking about economic development, he said we should note that all our actions end up in economic development. There are some things we do in our course. We don't really feel we are impacting the society. But for every simple thing you do as a lawyer, for everything you do as a judge, for everything you do as a registrar, everybody, all of us stakeholders, we are indeed impacting the economy. And to this end, fairness and timely protection of property rights should be our watchword. So, because all these actions are ways through which we individually and collectively impact the economy of our nation. So businessmen should be able to look at the courts and feel they can come around and get justice in the courts in doing their businesses. Then we must be able to deliver justice expeditiously, that the courts must be able to deliver justice expeditiously and timeously, especially in economic cases. Refer to Lagos, where they have commercial divisions and all the rest. This state we are still evolving. And very soon, it is my belief that we might end up having commercial departments. More so when we are looking at bitumen exploration, looking at deep sea ports and everything. I'm of the belief that very soon we shall get to that. Then he said, our actions, these are things, our actions, our day-to-day actions in the courts are things foreign investors will look at to determine whether they can come here and invest. If somebody is making millions in dollars to come and invest in Nigeria and in those states, we will first of all look, if I run into murky waters, how do we resolve these issues? How long does it take for these commercial issues to be resolved? That's to tell us we are very, very much involved in economic development. So they will look at the ground. What is the efficacy of alternative dispute resolutions, ADR, and all the rest before somebody will say, okay, let me put my money down for development and issues in Nigeria. Then, talk about small, that this thing touches around small and medium scale, large corporations, and all the rest. So, long and short is this, that the judiciary does not, that they will look at it whether the judiciary delivers their judgments, do their cases expeditiously and timeously. So the long and short of our discussion is just to tell us we are all involved. And we should be deeply involved in ADR. She's an ADR professional and she knows it all. So she ended up putting numbers 10, 29. My Lord Justice Sifat took us back. Yes, my Lord Ipat, when she started, took us down memory lane. She reminded us of philosophy year 1 and jurisprudence in the final year by quoting Jeremy Bentham and his popular dictum in the greatest book for greatest number of people. So that a judiciary should be independent, impartial, accessible, and promote social welfare and economic prosperity in our society. He said outcome of court cases should be such that businessmen will develop some kind of confidence that they are coming to, invest in our economy. These are the areas where our activities impact the economy of Nigeria. Spoke about sanctity of contracts, talked about accountability, then accountability of political officers. When these judgments are done, how do they handle them? How do they obey these judgments? Spoke about delay, who is responsible for the delay? He said, you and I, court registers are responsible. So, you, I, and all of us are responsible. Judges, lawyers, registrars, bailiffs, bar association, all of us are involved. Especially if we fail to play the necessary roles we should play. She took us, at the end of this, she concluded, preached to us about going back to our customary laws, and we should embrace customary law, customary litigation, customary adjudication. And like she said, she posed the question. I guess that's a rhetorical one. She doesn't understand why chieftaincy and family land dispute should be at the High Court, especially when we have customary courts and have them in numbers. Thank God we are tilting towards engaging qualified professionals to handle our customary courts these days. There are so many of them around here who are lawyers, well trained, who are presidents of customary courts. So, according to her, we should embrace customary adjudication and see how we can integrate it and make things work perfect. Well, my only two contributions, I would like to talk about, it says, promoting electoral justice through legislative and judiciary as a catalyst for economic development, efficacy of court judgments. They've told us what our involvement in economic development. I just want to air my view about efficacy of our court judgments. When courts are given in court, how do they obey them? Just like they said, what foreign investors will look at is that, okay, we are talking of delay. What about the ones that were taken to their conclusions? Court will issue judgments, court gives orders. How do we obey these orders? In my court recently, I said something related to that yesterday. My court made another. I made another. This hall where you are seated was completed since 2017 and has been in use since then. I know I've not attended any function in this hall. I've attended more than 10 or 20. It will be interesting to know that the contractor that finished this job was not paid until 2025. Yes, the case went to court by my Lord Enrico. Over time, gave a judgment in favor of the judgment creditor. And for several years, that judgment was disobeyed. It was not obeyed at all. Then they came here, garnishing proceeding to my court. Came by way of expertise application asking for another license. The other license, the court looked at it, granted another license. Called on almost all banks in this area to come and render accounts. Do these people, do the judgment people have any account with your bank? Eventually, they brought about 16 or 17 banks. Eventually, one bank owned up and said, we have more than enough in this account to certify the judgment debt. The court went ahead, made the order absolute, and there was wahala. Trouble started. Some people somewhere drove to that bank and warned them if they obey that order, they will be in trouble. That they will take all their money away from that bank. How do we obey court orders? How do our authorities flout court orders? Eventually they came there from 48 and 49, and the day they came to court, they were I told you about one application yesterday, I won't emphasize that any longer. And the bank said, we've checked our bank, they have account with us. This court made the order absolute. Before they floated that order, and they came by way of application, and the bank came. I said, for how long shall we continue doing this? Foreigners are looking at us. Outsiders are looking at us. If orders are made, I just laughed. I knew where the pressure was coming from. I went to the CJ. He said, people, what is happening? You know the man is not there. What is happening in your course? So, person has called, so person has called, so person has called. What is happening in your course? What is happening in my course? I had issued an order. That order must be obeyed. I so much trust the CJ. When I explained to him, he said, my lord, someone should share Jerry. I will not do Allah. I go back to that court. I told the bank, the council, I said, I am waiting here. It was around 9:45 in the morning. I said, I give you to 12 noon. A minute after 12 noon, if that order is not obeyed, the manager is going to prison. Lo and behold, I attended that matter till 12 noon. Lo and behold, by 11:30, bankers checked that sum was ready. So, and immediately I said, hand it over to them. They got the checks in the court, and I said, the lawyer said, will you stand up and address me that you receive money? You got money now, you don't want to talk. So we just finish it here. What am I saying? When courts make order, and others are flouted, we are not giving a very good impression of the judiciary. International media, they are all around. What we do in court and we feel nobody is seeing us. Everybody, throughout the world is a small village now. Tomorrow you see on the social media, somebody in America will read it and call you. Somebody in Australia, the next thing will read it and call you. So I'll just tell us, let us be conscious. It's a message for our authorities. Then the role of counsels too. Some will even aid judgment debtors not to flout it. Some of us will tell litigants to run away, don't come. I don't know what happened in Fidelity. That somebody called me to intervene. It involves one of our colleagues here. They flouted the court order, and the court ordered that the manager be arrested. She started running around, calling people. When they called me, I said, what are you? You are joking with your safety. Will you, because of another person's money, flout the court order? And you're asking me to, I said, I cannot take that man. Tell your people to obey that order first. If you have any other thing, you can go back. So these are the ways our activities impact the international community. We are hoping on those days we leave this stage. We are hoping on those days we develop. To the point we have commercial divisions, and then we begin to see influx of commercial. These issues are very, very important when it comes to commercial cases. Because outsiders are looking at us. They see what we do. They know how long it takes to decide the case. And even when these cases are decided, how do we handle these cases? On this note, I think I rest my case. Let me not continue to do the job of the chairman. And hand over the proceedings at this session to my Lord, Honorable Justice Emmanuel Bamidele Omotosho.
Thank you very much. Distinguished ladies and gentlemen, the chairman of the session is a very quiet person. He walked into the hall very quietly, and he has sat down very quietly, and he has enjoyed every part of the conversation. But it is appropriate that we welcome him to this session very, very properly. I therefore wish to welcome the chairman of session, the Lord Honorable Justice Emmanuel Bamidele Omotosho, all the way from the state. Let's put our hands together for him. My Lord, the chairman of panel of session, will now take over.
My lords, I sincerely apologize for my lateness. It was unintentional. Actually, I left office around a few minutes past 12. As the time the chairman called me, I was at Isharo. I got to Akure. I used Google. Unknown to me that so the Google man led me to the bush, and he said, "You have reached your destination." I said, "This is not my destination." Even when I was going, when you were going, I told my ex, when I saw us of assembly, I told them this is where my dad taught me how to drive in the olden days. Unknown to me that I was even close to the place. The chairman called me. I said, this road is under construction. How soon can we get to this place? He said, "No, just be coming, they wait for me until we got to the bush." And we were told that, "No, we have missed our way, so we have to go." I'm very sorry, please accept my apology. May not the, let me start with the chairman. MB, no, let me congratulate the chairman of the Akure branch. For the law week 2025 law week, I was once the chairman of the MB2. I know what it took to gather people like this. You know, lawyers are terrible. My clients are waiting for me. I want to attend to this or that. But I can see they put some maybe experience or findings into it. By bringing arranging the program in such a way that lawyers will have time to attend to their cases and at the same time attend the program. I wish you good luck and success. We are still at the middle of the law week, and I pray that it will end well in Jesus' name. My chairman, the chairman law week, that's my friend Dayo Akela just said. He called me on the phone and that I said I will go out and attend the program. My alternate chairman may not Sunday, I should go to see you once again. I didn't even know that I would be the one to act on my behalf. So I was glad to see that the job has already been done. Let me continue with where we stopped. I won't make my own contribution known, because I was not a party to what has taken people in my arrival. I think my own concern is about the efficacy of court judgments. Let me start as a one-time legal practitioner. How do we enforce court judgment as counsel? I've seen occasions where a lawyer will get judgment and will not even bother to collect or ask for a copy of that judgment. Maybe after a year. I can remember sometime early this year, a lawyer, I delivered a judgment almost over a year ago. Only remember to ask for a copy after a year. How do you enforce that judgment? Except those of us who want to, who aspire to be SCN or judges. Most of our colleagues, they are not bothered. Once they get their fees from their clients, they are okay. So the process from there, we have to ensure that justice is administered fairly and effectively enforced. Secondly, as a lawyer, when I used to take proactive action. Once I know that this woman will be in my favor, particularly as a claimant, I started taking steps. Immediately I got the judgment, I will make sure that I got the enrollment of order. I don't wait for a full judgment. Let me give you an example. I had a case against GTB in those days. I got a several copy of judgment. They were to pay 5 million plus damages and to vacate their branch office there. I said, don't worry, I know it will be difficult to enforce that issue of vacation. But that 5 million, I will get it. I mobilized the sheriffs. We went in there with one of my lawyers. When we got there, I want to meet the manager. I want to see the manager. He came out, sir, I have a judgment against the bank, and I read to enforce it. He was arguing with me, this or that. Immediately, we are up. We are disabled the computers. Immediately they called the head office, they paid me the 5 million cash. I took it to the office. So this is one of the ways. But some of us will wait. We don't even find necessary forms to execute judgment. That's that's on the part of lawyers. Like as a judge too, by God's grace, though we do officially, I'm not, we don't have divisions. Where I handle my court is delivered as commercial division of the state judiciary. Because the way I'm handling your case, I don't allow you to waste my time. If it's monetary claim, I ask you how much I'm ready to pay. Immediately that maybe partially you admit, I will ask you to go and file your writ of execution. I will sign immediately. There is no law that stops a judge from signing a writ of execution on the day of judgment. I'm not aware of any law. Except there's pending or you find a notice of appeal and accompany with a notice of motion for self-execution. But some of us as judges, you will be a bit reluctant to sign all these papers and thereby depriving the judgment paid the fruit of his labor. Then this issue of now we're in this Yahoo days, they will bring expertise. We had a meeting sometime, some of our colleagues were saying, no, we should not be granting this application. I say, I pray it will not be, you will not be a victim of all these young boys. You know the practice of police these days, they will approach the court, ask the court to place no debit account and request for statement of account and bill, whatever. It has saved a lot of people from committing suicide. Then we are happy to say, no, the rules of natural where you can do that. And I'm happy there's a case recently that police don't even need the order of court. They have the power to investigate crimes. But banks, they are always afraid. Without court order to place no debit account, no debit pulse on your account. But I can remember one of the victims, a proposed law student. He had 1.8 million, no, 1,080,000 or so in his account. The money he was to pay for his school fee and whatever in law school. So the matter was heard by the Minister of Justice. He came to me, sir, how should this big boy is a problem, I should go and bring your application. Most of the applications I had at the time them in chambers, everyone was not falling. Except to have a skeleton in your compound, you be afraid of what anybody will say about your judgment. And like the dad is straight, and we used to say that courts do not make orders in vain. So you as a judge, why not ensure that your judgment is obeyed and enforced? It's by doing this that you can attract investors. People can sense justice, public trust and confidence will be enhanced. So we have to do that. Then when I was talking about politicians, I'm not supposed to go to that area. Political office holders, are they obeying judgments? If you are handling a matter now, if you feel that this thing will not favor the state or whatever, you see them running up and down. I remember one judge almost suffered for signing a garnishing order. Suffered almost lost his job for signing a garnishing order. In a situation like that, even as the Attorney General, you can approach the court for instrumental. There is a provision for that. Instrumental payment of judgment debt. So all these things, we need to look at them to ensure that our judgment is enforced, is recognized and respected everywhere. And this is how we can enhance people's confidence in the judiciary. Two, there must also be the judges must be bold and courageous to determine, to give any judgment. Once your conscience is clear, forget about whose fault is God. You cannot, as a judge, give a judgment and expect the both parties to be happy. It's not possible. You have chosen to be a judge, so you're going to be a judge until you retire. So you'll be expecting that. You should be courageous to give judgment that people will know that yes, we still have independent judiciary. Finally, this idea of delay of cases, block of cases in our courts, lawyers contribute, so also the judges as well. I have my own style. when you have a matter before me, maybe has to do with memorial matter, I'll say, okay, let us look at it together. I'll look at your playlist, look at your, yes, I admit that I'm owing 1 million or 2 million. Okay, I'll give them immediately. You must pay that 2 million now before you can do the other parts. You don't wait when you conclude matters. The rule permits us to do these things. I will look at you go and find it of execution and take that whatever judgment saw. Then you go higher. At times you narrow down issues. What is the problem? You are complaining that your account was falsified, was falsely inflated or whatever. Go and do your own. Let's look at it together. So by this, we facilitate quick delivery of judgment, and then the other steps will be taken. I was thinking that we can have special sheriffs for the enforcement of judgment judiciary. At this high time we have this. We have our own police or enforcers, judgment enforcers. I'm not talking of sheriffs, or these are very soon. Even if they get there, by the time you monetize or even they can compromise. Then when you have somebody who knows that my duties are at stake, he will do everything to protect it and ensure that judgments of the court are obeyed. So I don't want to waste time. I think, I will now go straight to entertain questions and contributions in response to what you have heard from the discussants and chairman of the occasion. Thank you. Okay. Yes, I will give leave or permission to 4 participants to ask questions, and each is entitled to 2 minutes. Thank you. The chairman, yes, my brother, just any comment. Just say any comment. Yes, sir. We'd like to hear from you, sir. Okay, favorite, yes, I think we are 2. 4, please. Yes, let's start from Nane Sik. Please, let's start from this side.
My Lord, all protocol duly observed, members of the bar. My Lord, I will share my experience as both a lawyer and litigant on this issue of judiciary and the need to have a strong judiciary that can protect the economy. In 2011, as a young counsel, I approached the court and I saw a circular issued where it was stated that the governor of Ondo State has increased the court fees as follows. Disturbed at the intervention of the executive, I filed an action before the High Court. And behold, the judgment was against me. I have no local standing. That is the famous case of Charles Silva versus Governor of Ondo State. I proceeded to the Court of Appeal. That judgment was delivered within 6 months by Honorable Justice Abida Tayo. We proceeded to the Court of Appeal. The present Chief Justice of Nigeria was here in Ondo State that time. That is Justice Kekere. He affirmed the judgment, that is 2013, which went to the Supreme Court. Interestingly, that case has been in the Supreme Court since 2013 to date, no date for hearing. And these are cases sponsored to protect the interests of the judiciary by members of the bar. I don't have vested interest, but I find it repugnant that the executive arm of government can create court fee and it can be in the circular released by the chief registrar of the court. I think we need to encourage ourselves, support a
a situation where there is synergy between the bar and bench in the protection of an independent judiciary in Nigeria. That is the only way. Outside that, we may not be able to go far. And I want to contribute briefly to what Honorable Justice Akeredolu has stated concerning ADR. When I was the Attorney General of Ondo State, we started a department of ADR in the Ministry of Justice. That is the first time in Nigeria, the Ministry of Justice, we have ADR department. When I appeared before the Supreme Court, I took one of my directors to the Supreme Court. And when I introduced him as Director of ADR, Ministry of Justice, they were surprised. They said, this is good. That if Federal Ministry of Justice, we have ADR department, the case we brought, because all of us are together in the entire federation, sue the federal government when there are issues of cash crop in this country. They were swapping currency. Things were hard. People were staying at the back. All of us sued the government before the Supreme Court. But when I introduced my colleague appearing with me to be director of ADR, the Supreme Court Justice saluted what we did in Ondo State and said, if Federal Ministry of Justice has had a department of ADR, maybe they could have resolved this matter without invoking the jurisdiction of the Supreme Court to resolve it. And I said, the best way to resolve some of these issues is ADR. This is the truth of the matter, because our courts are congested. And as long as the courts are congested, there's no likelihood that cases can move as fast as they're supposed to move. Finally, I wish to say this, that we need to...
You have 30 seconds more.
Thank you. We need to encourage ourselves as legal practitioners. The old style, when we draft deed of assignment and we put litigation to be the cause of disputes among parties, we need to put ADR there, arbitration first, before going to court. If we are able to do this, we save court of a lot of litigation. Thank you very much.
Thank you very much. Nane Sik. Yes, Chairman. Oh, may Lord Justice.
Okay, thank you, Lord. Let me first empathize with you on the Google direction. I believe we have a lot of action against Google at this time. But then let's leave that. Now, it's been a very rewarding afternoon with them, Lords, and their opinions are not very deep sensibilities. Particularly, my Lord spoke about the pursuit of the efficient judiciary. I just want everyone to know that when you talk of judiciary, people tend to look at judges, magistrates, and court system. No, it's a system. Begins with the lawyers, the litigants themselves, to the court of enforcement. So we should not just isolate the High Court, the Government of Appeal, the court system, and call it the judicial system. No, we don't have powers of enforcement. Like I said, like my Lord the other said, when this case was not paid for, I stood my ground to say, state government go and pay. And I thought it was going to be obeyed within a matter of days. I was just shocked when he was telling me a few days ago that the matter that I started a long time ago was just being said through garnishing proceedings. So a lot of these things lie in the hands of our clients and lawyers as well as judges. Let us fix Nigeria. All these things will fix. I agree with you that economic development and the sound judiciary are mutually inclusive. So we cannot advocate them. I not mean that. Let us fix this country, fix the system, and every one of us will work well. Now, talking about one more initiative, I am aware that the small claims court is being proposed in Ondo State. My Lord Akinwumi has done a lot of work regarding it. And the idea of the small claims court is to ensure that a threshold, maybe 10 million, below 10 million, we just go to the court. Just we all watch Judge Judy, we all watch Judge Brown, and a lot of those assizes in America. It will just go there. We don't need all those lending, filing on this one. It will be another way to ADR, which is also good, so that compulsively, whenever the substantive matter, not the case, not the other case, are below 10 million naira, 10 million naira below, it must go to the small claims court. And the small claims court, you have a date. The moment you get to the small claims court, then it must be done within a few number of days. So I think that's an initiative that the bar is also encouraged, just like the ADR. But let me also say that in France, I am aware that they have what they call the judicial police.
Melody, you have 30 seconds more.
The judicial police, we can introduce something close to that to enforce judgment rulings and decisions of court. And the moment we have, because sometimes decisions of court will take it to the commission of police, and he will tell you he wants to study it, and you will not carry it out. So, I mean, it becomes mostly for a judge to give order, the right will be there to enforce it, but the policemen are not there. So thank you, Milord.
Thank you, Milord, for your contribution. The chairman.
Thank you so much, Mr. Chairman. I want to most sincerely appreciate the panelists. And a quick one, my Lord, I also want to confirm what you have just said. I appeared before my noble Lord, brought an application for summary judgment procedure. My Lord read through my application, he said, okay, this one, let's grant it, come and prove leg 4 of your claim. And I immediately withdrew the leg 4. I don't want to come and be calling witnesses anymore. So my Lord, the aspect, you have really touched what has been agitating my mind, and that has to do with judgment enforcement. And perhaps this will give me the privilege to bear my mind on the procedure. As the chairman of NBA, I've got calls from colleagues from Oyo State, and in particular, they've got judgment. Now they want to enforce it in Ondo State. It's as if it is just like a camel trying to go through the eye of a needle. That I didn't understand then until I was personally involved in one. The procedure where you want to kickstart an enforcement, you come to the registry, then you fill the necessary form, you are taken to the bailiff session, he fills his form, from the bailiff session, you are going to correspondence, and that is very strange to me. I don't know what I'm going to do in correspondence. From correspondence, it takes you to litigation, from litigation to the, I think, to the chief registrar for final approval. That is for you to get the form to say, go and execute. And when you now come back again, you come to the bailiff, of course, you are giving, well, I don't want to use the word bill, but you are trying to call it bill now. And all of this, I felt that enforcement should be sober. And the funny thing, there's this other, go and verify whether there's a pending application, pending application. When the time for all of these have passed, and all of that, yes, we know we shouldn't execute a judgment when there is an appeal pending. But the process of even most often, sir, to verify that takes too long in time. And we have had instances, I had one particular experience, we brought an application to sell an immovable property. Now, this application was granted, we were moving from one office or table to the other. My own client agreed, which we are the judgment creditor, agreed with the judgment debtor, sold the property while I was still pushing files from table to table, and they settled themselves. And for me, the process, for 4 months, I was on this. If I do not go to say, take this file to the next place, so that it can be approved on that table, the file will be lying found there. And all these things should ordinarily move effortlessly. I don't need to go and be processing it. For me, I think the enforcement aspect of it, like my noble law suggested.
Mr. Chairman, you have 30 seconds.
Thank you so much, my Lord. So in my own view, there should be a special way of doing this enforcement. Such that, in fact, the aspect that the Commissioner of Police will have to approve and do all of those things before they go for execution and all of that, for me, is too long. And most often, the judgment debtor gets to know a rush to go and file an application you know may not even fly at the end of the day. But then if the application is pending, you cannot do anything. So we hardly can execute judgment, and that is painful. This is just my contribution.
Thank you, my chairman. Last, okay. Famoriti, Mr. Famoriti, please. So. The last. I'm not going to say the time.
I really appreciate a lot for this great opportunity. Still on the same wicket of enforcement. I
I want to say that it's very easy to get judgment in Ondo State, but to get the judgment executed is a problem. Fine, you can, within a year, you can start a matter in Ondo State and you get judgment. But to get the judgment executed has now been the problem. Now, I have about even more than 5 cases that I have. I've gotten judgment, we processed all the execution papers and all of that. Until now, over 6 months, the judgment has not been executed. The writ of possession have not been signed. But I have 2 that are pending before the CJ now. All the excuses that the CJ traveled, the CJ is not around before. How long do we continue with this? And we are talking about enhancement of the lawyers financially. We are talking of the lawyers getting money financially. How do you get money as a lawyer without, when you have documents not being executed? There is no way. So we are getting poorer and poorer. So I want to bring this to the notice of my lord, sir, that we need to do something very pragmatic about this. Another worst aspect of this is that when you get a judgment, particularly in that matters, they tell you that declaratory reviews are not they are not executed per se. You need to go back to the court to seek for possession. What is not the essence of getting judgment in the first place? When you have declaratory review, somebody has trespassed, the court has declared the person a trespasser, perpetual injunction and all of that.
Thank you, Mr. Favoriti.
We need to go back to the court for possession when we continue judgment in the first place.
That's okay. We are happy and we appreciate your contribution. Yes, I want may not Oshadon as indicated his intention. Ọlọ́run dáhùn sí, sorry, we have insurance in our area. Ọlọ́run dáhùn sí. So let's hear from him. They have just summarized what you have said.
Thank you very much. I will start from the last speaker that talked about, I think the issue is raising, my Lord Eniku has suggested, brought down also special sheriff that will execute some of this. One problem within the system, like the learned professor and my learned brother here said, we are all involved in these issues. When issues like this arise, how far do we go in complaining to the system? Like you have 5 judgments and finding difficult to execute. Most of these things are not known to the head of the judiciary. The CJ is not aware. Until you complain, and you say, this is what I'm experiencing. That's why mechanisms will be put in place to make sure this problem is resolved. We have found out that we should be the conduct of this justice system, in our different spheres. I remember there was a time in this Ondo State judiciary, the CJ woke up one day and issued a circular and said in the circular, signed by the chief registrar, that so class of cases cannot be tried by magistrates. This is totally different from what is in our criminal procedure law, criminal code law, criminal code act, and everything. But he issued it, and magistrates adhered to it. But a lawyer woke up one day and challenged it in court. He brought an application before me, challenging that directive. And again, some Minister of Justice, they challenged it. And lo and behold, I said, no, my Mr. CJ, you cannot use administrative directive to change the condition of law. I said the CJ what he did was wrong. I get that order. It's because that order was given because a lawyer somewhere saw this thing that is not right and challenged it. So if some of these things are happening and we don't do anything about them, we don't challenge them, how do we know they're happening? So, and that order, the CJ said they should told the Minister of Justice they should appeal. Minister of Justice looked at that order, looked at everything, they said there's no way we can appeal this judgment. You cannot, they didn't appeal. And I think today, those class of cases are back to the magistracy. We are talking about congestions in our courts, and yet we are stopping magistrates from trying some. Instead of even looking for a way of giving them more. Why would we do that? So what I'm saying when these things are happening, let the appropriate authority know, let them be aware. I know solutions will be given. Thank you very much.
Thank you, Milord. Yes, we have come to the conclusion that on small scale, small claims court, we have a small claims court in Ekiti, established about 4 or 5 years ago, and they are functioning well. Yes, functioning very well. So I think we can emulate that here as well. Then finally, I didn't even know that the chairman ever appeared before me. I couldn't remember his name that he has attested to the fact that my people used to call me Papa Judge. I don't waste time on any matter. Bring it before me, I determine once and for all. Once again, I want to appreciate our panelists, Milord, who acted both as acting chairman and acted as chairman and discussed as a panelist. I appreciate your lordship. And for all of us, for sparing their time to attend this program, I have to appreciate. Though it's not my business to do that, but as a former chairman of NBA, I know what it is to be here. Thanks and God bless you.
Thank you very much. Now we'll do a photograph very quickly before we move to the next thing. We are the photographers. Please let's be quick. Thank you very much. Your lordships. The first and second panelists of the first and second sessions will take their turn after second session. So let's do the group photograph very quickly. Thank you very much, Mr. Chairman. Please, the chairman of the branch should join them. Thank you. Okay, sir. Mr. Chairman, you will stand in the middle. Yes. The chairman of the branch should be okay. Thank you. Thank you very much. Thank you so much. Panelists of the second session, please may I request that you step to the podium for your photograph. Panelists of the second session, please, it's important, there are announcements. Once we're through with the vote of thanks, there will be lunch. And let me quickly explain how we are going to deal with that. All the participants will move to the second hall for their lunch. Sit there and you will be served. While the panelists will move to the space, to the VIP space in this hall. Thank you very much. My lords and magistrates, let me welcome media icon, Mr. Adeyemi. Thank you very much for joining us. Exceptionally quiet gentleman. He always moves quietly to any arena. You hardly can notice his presence. So let me invite Barrister Shola Ajisafe to step to the microphone for the vote of thanks. Barrister Ajisafe, please.
Just before he speaks to us as per vote of thanks, may I respectfully please refer us to page 48 of our voucher and to draw your attention to the various events slated for tomorrow and the clamors at 5 p.m. tomorrow, the dinner and award night. Please let's take note, and of course, we always encourage punctuality because of the urgency of time and of course, and its value. Thank you very much for your attention so far. We wish you all the best. Please, Mr. Ashola, Shafet,
thank you.
Vote of thanks.
Yes, it has been, let me call it a week of exploits. But we cannot go away from here without thanking all of you. How to proceed is difficult, but how to do it one way or the other. Let me start by thanking the participants. You have been very, very awesome. And we thank you. And many of them have gone to the lunch area. But I'd like to thank all the magistrates. You have been very, very awesome. We thank you for your support. We thank you for your being here. And whatever we have done that may not agree with you, please forgive us. We thank you. My Lord, we want to thank you. Even though you are moving towards the rear arena, we want to thank you. We thank especially those of you that came from outside this jurisdiction. Thank you so much. My Lord, please, before you go for your lunch, you need to take a photograph with Senator Olajumoke. Papa, we want to thank you, sir. Dr. Bode Olajumoke. You have done us a great thing, and God will continue to reward you. God will continue to reward you. Baba De Ayeni, we thank you too. Everyone present here, we want to appreciate you. All our judges, we thank you. Senior Advocate of Nigeria, leaders of the bar, thank you, and thank you. Please join us on Thursday for our dinner. And tomorrow, please, we are expecting you for the dinner here tomorrow. Thank you, sir. Photographer! Please, somebody to help us call the photographer from outside, please. Please. My Lord, please, just 2 minutes. Let's get, because this is going to be a historical picture.
So, thank you isn't enough to appreciate the lordships, to appreciate the executive of the NBA Apparel branch, to appreciate the chairman of the planning committee and his alternate chairman, to appreciate Daddy Bode Olajumoke. Thank you very much. At all the sessions you have been present and you came very early, and you have stayed up until the end of each session. Thank you very much, sir. The magistrates will now take their turn. Thank you very much. And so, we will meet here tomorrow. 4:30 is the time. 5 o'clock we hit the ground running for the award ceremony. The dinner and award ceremony. The magistrates are looking excellent. All looking very gorgeous and radiant. Thank you for the great works that you do. Thank you once again, everybody, and God bless you.